This entire time I'm talking and you guys cannot even hear me. Let me know if you can hear me now. Girl, I done gave a whole speech, gave a shout out to Missouri. Let me know if you guys can hear me now. Let me see if it's moving. Oh, it's not moving. Hello, 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 hello. Hello, hello, hello. She said, yeah, we can hear you. Okay, okay, okay. Y'all, I had gave a whole speech. I done gave a shout out to Missouri. Somebody in here said, I am here from North Kansas City, Missouri. I done gave Janae Hunter a shout out. Welcome to the moderators that are in here. I see you, cute. See, I know some people are not going to be able to be here because it's extremely late. This is a Saturday night. It's 11 o'clock. It is 18 pages worth of documents that we have to go through. So we're going to be here for a minute. If you can't catch the whole thing, you can always come back tomorrow and pick up where you left off. All right. She said, I'm from Kansas City too. Hey, Tisha, I never knew you was from Kansas City. I never knew you was from Kansas City. Kansas City in the house. All right, you guys, this is a lot to go through. Okay. So I'm going to ask a couple of things from you guys. All right. For tonight. I got 137 people in here. Please hit that thumbs up button. That's one. But for two, can you please not bring up any other topic while we are covering this topic? Now, it's unfortunate I have to say this, and I'm going to start saying it in the beginning of each, well, I'm going to try to remember to say it beginning of each live stream. But please do not bring up other topics while we are going over this topic. Moderators, if someone brings up another topic, please just delete their comment so it won't be distracting. All right. I would like to start sticking with what we are blogging about. Tonight, we will be talking about the 18-page document that was sent up by the defense attorney Ari, to the appellate court. Okay. This is a very important portion of this case, and I would like to go over each document and explain it from my vantage point, all right? From my point of view. I do have a goal, I think of 20 super chats or something like that, 20 $10 super chats. If you cannot afford $10 or not even afford, but if you just don't have it to give this month because of whatever, whatever the situation, if you want to give lower, you can. And if you want to give higher, you can too now. I mean, it ain't capped. Now it ain't capped, okay? But go get you something to drink right quick. I have my water over here, so I'm definitely prepared in the water capacity. And I also have some crackers that I'm going to be probably snacking on, but probably won't. I'm snacking on them now, but I probably won't be snacking on them. But anyway, y'all, there's a lot to go over. All right. Now, I don't know if you guys want me to pull up each document and put it on the screen. Y'all let me know in the chat if that's what you would like, or would you just like for me to just go through the documents without putting them on the screen? Let me know. I know some people like to interpret things for themselves, so they want to read it straight from the screen. If you want me to do that, I can. I have no problem. Let me know in the chat. She said, by the way, I'm new to your channel. Oh, Janine. Oh, welcome. Everybody welcome Janine to part of the Loud Talkers. If you're new to the channel, we are Loud Talkers over here, honey. We call ourselves the Loud Talkers. There's so many people on social media that wants to quiet us, and we would never allow anybody to quiet us, to shut us up. So we call ourselves the Loud Talkers, okay? So welcome to the Loud Talker family. Welcome, welcome, welcome. We don't bite every day, just on Tuesdays and Thursdays. No, I'm just kidding. I'm just kidding. So are we putting it up so that whatever's easier more? All right. So I think I'm going to put maybe one or two up just to let you guys know I do have the 18-page document. And we're going to go from there. Okay. So if you are new to this story, we are talking about the Holly Johnson versus the state of, well, really the state of Illinois versus Holly Johnson. Okay. Now, if you don't know, September the 8th, there was an unaliving in Chicago that involved two females and one guy. All right. So we got Carlos is the guy. He is also witness number one. We have Romika Meeks, which is victim number one. And then we have Holly Johnson, which is the defendant. All right. So there was an incident that happened September the 8th, which ended Romika's life. There is back and forth on the internet right now and in the courts about whether she was justified self-defense or was it just cold-blooded murder. Okay, she was charged with first degree, meaning intentional killing of Ramika. Her defense team says it was self-defense. Right now, she is detained in Chicago jail and has been since December the 3rd when she was arrested. And two judges so far have said no, she cannot be released. Ari said, "Oh, you got me effed all the way up." She went before the appellate court saying, "Let my client loose." Okay. She's basically telling the courts that they got it wrong. All right. That they did not do their due diligence and find that she is not um, a threat to the community, okay, and that they did not prove that it was first degree murder, okay. So she is asking for the appellate court to overlook, not overlook, but to look at it again, to relook at it, and to release her from detention so that she can fight from the comfort of her own home, fight her case from the comfort of her own home. Okay. So the appellate court filing is out. It's 18 pages. Y'all, in my opinion, it goes in great detail, way more than we knew. Okay. Now I did hear that other people have went over this, so I hope I'm not redundant, but I will be giving it from my vantage point. Okay. Now, let me just say this before I continue on. Things that I say out of my mouth is based on my opinion and my opinion only. Okay. My mouth based on my opinion only. All right. So now let's continue. Let's pull up the first page. Let's take this down. So this is page one, you guys. This is page one, and it's the Appellate Court of Illinois, First District. Okay. Now I know you guys probably already heard that this was filed on the I want to say the 19th. Was it? Let me see. No, it was filed on the 12th, but it was some things uploaded on the 19th, and we're going to get to that in a minute, okay? But this was filed on the 12th. I just got a hold to it today, and I have been combing through it, reading it, and yes, I am like, whoa, okay, so there's more things that have come out, and I'm seeing things a little bit clearer now, okay? So, and we're going to go with that as well. So, people of the state of Illinois versus Khadijah Johnson, which we're going to be referring to as Holly Johnson here, okay? Holly, all right? So anyway, it says here, I'm not going to read everything because we already know that her attorney is Ari and she's going up against the prosecutor, which at this point, I don't even know if the same prosecutor will be prosecuting the case. The judge is Judge Clancy. Actually, I think Judge Clancy, Judge Clancy. Okay, I was going to say, I think he was the first judge, but no. I think Judge Clancy is the second judge. Okay, this is the one that made the last ruling, okay, when they did the appeal, and he says, no, and this is the reason why, right? So that's Judge Clancy, all right? So now, Khadijah Johnson, who we are going to be calling Holly Johnson, is being represented by attorney Ari. And they took this before the appellate courts, all right? So right here, it says, in December of 2024, Ms. Johnson sought a no stalking order. We all know that. We've all went over that no stalking order that she sought in 2024. She asked for it to be an ex parte. It was denied as an ex parte, but it was set up for a hearing, and after the hearing and all of that or whatever, she ended up getting the order by default. But here it says, in December of 2024, Holly sought a stalking no contact order against the deceased, which is Romika Meeks, alleging numerous threats made to her and through Mrs. Johnson family members. So the threats was made not only to Holly, but also to Holly's family members. Holly was pregnant with her first child throughout her actively seeking of this order, having appeared at each scheduled court date. So basically, she was saying she was being harassed and stalked while she was pregnant, and despite the fact that she was pregnant, she made every court date, okay? Holly did. So on June the 18th, both Miss Holly Johnson and the deceased Romika Meeks appeared via Zoom to address the issue of whether the order of protection would be granted. Now, we all went over that June the 18th, where we read the transcripts where they were in court. Y'all remember when Romika called her ugly? Y'all remember that? Okay, let's take this one down. So basically, she's saying that she was present. And the reason why she's saying she was present is because she's trying to say, make no mistakes about it, she absolutely knew about the order. Okay. So that's why she said that they were both there. So it won't be no mistakes of, oh, she didn't know about the order. All right. So it goes on to say, July the 14th, 2025, Ms. Johnson was granted a default order of protection after the deceased failed to appear in court over Zoom. Although the default judgment was entered and the deceased may not have been formally served, right? The deceased was well aware or was aware that the order of protection was being sought against her. How did she know? Because she appeared June the 18th and she was served right there in court. So she very much knew that there was an order of protection being sought against her, and she knew what the accusations were that she was accused of. She did nothing about it. She didn't show up. Neither did she come back later and say, I want to fight this. This is not true. She lied on me. This is absolutely not true. Romika didn't do any of that, all right? So on September the 8th, just about 2 months later, okay, at approximately 8:56 in the morning, Holly and witness one, which is Carlos, who are in a dating relationship, left witness one, Carlos's home at the 2100 South Block of State Street with their 6-month-old son after spending the weekend together. Now, when y'all see this in parentheses, R236368, I'm assuming that means receipt, okay? Receipt 143, receipt 23, 63, and 68. Now, I'm just assuming that that's what the ARA means, the receipts, okay? So not only is attorney Ari providing what she considered facts from the defense point of view, she's also uploading receipts, or should I say mentioning receipts. Now, have she uploaded them yet? I heard that she didn't upload all of them, but she will be uploading all of them because the appellate court wants it all right? So again, witness one, which is Carlos, black Mercedes-Benz left the alley near his home at 8:56 a.m., making a left turn onto State Street, a right turn on Cermak, and parking parallel to the front of Miss Johnson's parked black Chevy Cruze on 20 West Cermak. So right here is saying that they have a receipt, video footage, where Holly and Holly and Carlos left his residence. There's a video of them in the alleyway getting in their vehicle and driving. And it shows where they turned and where they pulled up next to Holly's vehicle. Okay. All right. So that's what this is saying. They left their home, got in the vehicle, went down the alleyway. All of that is on camera. And then they turned and pulled up to Holly's vehicle. All right. A little bit above front was of Holly's vehicle. Holly and witness number one removed their child from the Mercedes-Benz and secured the child into Mrs. Johnson's Chevy Cruze. Between 8:51 a.m. and 8:53, the deceased, which is Romika, dropped her 6-year-old son in common with witness one, which is Carlos, at school located across the street. How do we know that? That was captured on the school recording, okay? Oh, she said R mean record. Okay, thank you for correcting that. Thank you so very much, Jen. So Jenny said R means record, not receipt, okay? So let me make that correction. R means record, is on record, okay? And when it says on record, whether it was stated before, whether it's video record, whether it's written down, but basically stated before, okay? So thank you, Jenny, for that. Appreciate that. So again, how did they know that Romika dropped her child off at that time? Well, because it's on the school video camera where she got out of her vehicle, walked up to the school, entered the door, her and little Loso, and she came out alone without him. Okay. So that is all captured on camera, on the school camera, and they got it all. At approximately 8:57 that same morning, the deceased, Romika Meeks, was captured on video driving her white Kia sedan eastbound on Cermak, promptly making a U-turn on Cermak. Okay, that's on record as well. The white Kia traveling westbound on Cermak continued toward Mrs. Johnson and witness number one parked vehicle. Now, this is where I'm just going to bring this up just to re-familiar you guys to, well, I had did something on this one. Let me take this off. I was doing a little homework. Give me a second. For those that are new to this case and may not know the little eaches. So this is a Google map. Let me get out of this because y'all, you know, I was measuring some stuff earlier. So let me just get out of this. Let's go to Natural Teachers Academy. Let's go like we're walking. Here's the Natural Teachers Academy. So on video, it shows that Romika left the school, which is right here. Let's go back down a little bit more. This is the school that Lilos was dropped off on September the 8th, Natural Teachers Academy. She came out of this little gate right here, got in her vehicle that was parked parallel on this road, and she continued forward. She's on camera driving toward eastbound Cermak. She gets about right here. She sees Carlos and Holly, and she goes over into this lane, this turning lane right here, okay? She goes over to this turning lane, busts a U-turn, and they are parked the third car up, like right here. This would be the third car, okay? Right here where my arrow's at. This would be the third car. So she did a U-turn. She went in this lane, left lane, did a U-turn, pulled up, parked her car, blocked, and I'm going to show you where it says that she blocked them in. Well, she blocked Holly in, jumped out the car, and proceeded to say what she said. All right, so let's continue. I just want you guys to know that for this demonstration. So anyway, it says, the white Kia traveling westbound on Cermak continued toward Miss Johnson and witness number one parked vehicle. Okay. Now, the reason why I say westbound, she was traveling east at first, but when she bust that U-turn, she started traveling west. But she didn't get far because as soon as she bust that U-turn, as she was going west, she pulls up to the third vehicle, which was Holly's vehicle, and she stops, gets out the car, park her car, and gets out. Now it says, the deceased, which is Romika, double parked her Kia on Cermak behind witness number one's vehicle. Witness number one's Carlos. Miss Johnson's vehicle was blocked by witness number one vehicle and the deceased vehicle. Now it says record 2696. Now I'm going to assume that they mean that they have that on video. Okay, I heard that they had it on video or a picture of it or something like that or whatever, but they have it on camera where it shows, I think it's on a CTA camera or something like that, where it shows where Holly was blocked in. Okay, so Holly was blocked in. So it says at 9:02 a.m., a call was made to 911 by an unknown caller. So record number 91, she is given the call log to show that a call was made at 9:02 to 911. The caller described two black women hitting each other across the school of 22nd and Cermak. Okay, so right here, the call that was placed at 9:02 says two black women hitting each other. Okay, two black women hitting each other right across the school on 22nd and Cermak. That was the first call at 9:02. Though interrupted by the 911 dispatcher, the caller mentioned there's a black lady, seems to be the aggressor, but the woman with the green has the GUN. Okay? Again, record 114-17. The woman with the green was Petitioner Johnson, which is Holly. Okay. So again, this is what Ari is saying. The 911 caller that came in at 9:02 stated there are two black women hitting each other across the school on 22nd and Cermak. Now, some of the information that I'm giving you, I've never heard that before. Okay? All right? I've never heard that they were hitting each other, or let me take it back, that a 911 caller said they was hitting each other. Now, I did hear a 911 caller say that they were fighting. So now she said hitting in this document. So I'm going to read exactly what she said. All right? So, two black women hitting each other across the school at 22nd and Cermak. Though interrupted by the 911 dispatcher, the caller mentioned there's a black lady seems to be the aggressor, but the woman with the green has the gun. Why is that important that she said the black lady? She had already told the officer or the dispatcher, 911 dispatcher, that there are two black women hitting each other. But then she goes on and say, it seems that the black lady is the aggressor. Okay? There's a black lady. She seems to be the aggressor. But the woman in green has the gun. So right there, okay, she said it's breaking up. Is it breaking up? Is it breaking up, you guys? Let me know if this is breaking up, you guys. I don't know what I'm doing different. Rachel, is it breaking up? Rachel, can you go out and come back in? Go out and come back in, Rachel. Let Rachel know to go out and come back in, you guys. All right, let me continue on. I be trying not to read the comments, but then again, I don't want to. Oh, she said I'm back in. Okay, can you hear me now, Rachel? Is it better? For anybody that is breaking up at any time, can you guys step out and come back in? She said it was breaking up, but now it's fine. All right. Well, let me just maybe put my mic back a little bit. Okay. All right. What about now? I just put it back a little bit so that you guys, so I won't be too close to it. All right. So let's continue. All right. So, but I wanna point out that the caller of the 911, right? She made a distinctive difference in the black woman and the woman in the green suit. Okay, the woman in the green. Now I'm gonna show you where she said this, and I find it to be interesting because this differentiates the two women against, showing you that she identified both women, but she identified one as the black woman and one as the woman in green, even though she already said two black women. All right, so let me just pull that up for you right quick. All right, it says, though interrupted by the 911 dispatcher, the caller mentioned there is a black lady seems to be the aggressor. All right, hold on one second. Let me just do it like this so you guys can see it all. Okay. Seems to be the aggressor. But it says she seems to be the aggressor, but the woman with the green has the gun. Okay. So the woman with the green was Holly. There was a fight that ensued between Holly and the deceased after Carlos moved his car. The deceased continued to rush Holly when Holly shot. Now, this is again what the defense is saying. Mrs. Johnson remained on the scene after the shooting. Mrs. Johnson lawfully owned weapon was recovered from her vehicle. There were 3 spent shell casings. Mrs. Johnson was detained. She was a valid concealed to carry owner. Now, witness number 1. We're going to go into each witness and we're going to break them down. She said there's no sound. Okay. Okay. Somebody write in the chat if you can't hear, go out and come back in for me, please? Okay. I love the way Ari broke down each witness, y'all. Each witness. And we're going to go over each one of them. All right. Let's start with witness number one, which is Carlos. Witness one, actually, you know what? To be honest with you, I don't think this is where she did it at. Let me see. Oh, it is. I'm sorry. Okay, it is. So she broke down each witness. And baby, when we get to witness number three, honey, just hold your hat, baby. Hold your hat. Okay. So right here it says witness one stated to the police on the scene. We know witness one to be Carlos. Witness one stated to the police on the scene that the deceased ran up on Mrs. Johnson, told her, I told you I was going to catch you, and swung at her. He also relayed to the police that Mrs. Johnson told the deceased to leave her alone. Now, this is not saying that she just got out of the car and did this right away. She just kind of summed it up, all right? But this is the gist of what Carlos told the police body cam at the scene. Again, when one stated to the police on the scene that the deceased ran up on Miss Johnson, told her, I told you I was going to catch you, and swung on her. He also relayed to the police that Mrs. Johnson told the deceased to leave her alone. Now, witness two. Witness two is the DoorDash driver. He drove eastbound on Cermak, allegedly observing Mrs. Johnson, witness number one, and the deceased on the street where Mrs. Johnson and the deceased were arguing. He was unable to hear what was said by either party. She goes on and say further, witness two further alleged that witness one, Carlos, was standing between the two women, Holly and Romika, with his arms extended. That Mrs. Johnson advanced toward the deceased, which is Romika. All right. That is what he's saying on that one. Let's close that one out and let's get this bad boy up right here, honey. Now, let's finish it over here. I don't know why I got it like this, y'all, but I do. All right, so witness one, because this is still number witness two statement. Witness one pushed Holly away while the deceased stood with her arms crossed. Now, this is what witness two is telling the officers, okay? In his interview, witness one, Carlos, pushed Holly away while the deceased stood with her arms crossed. Now, witness two was at a coffee shop when the shooting occurred. Later at the scene, he identified Mrs. Johnson as one of the women arguing. Now, let's get into witness number three, because I find this whole breakdown of what she did with witness number three very alarming, okay? Very, very alarming. I actually found out some more information that I did not know before, all right? So, witness number three is the one of the individuals, or should I say is one of the only visuals that alleged to have seen the entire incident. Okay? Y'all know who witness number three is, right? Yeah. That is the state star witness. All right? It says at 8:57, while the deceased was making a U-turn on Cermak, witness three was in Chinatown, traveling on eastbound bus. Her windows was closest to the north side where Mrs. Johnson, witness one, and the deceased were located on Cermak. The bus windows were closed, okay? Bus footage also showed witness number three wearing thick wireless headphones. Now, we all knew that, right? Over-the-ear headphones witness number three had on her ears. The bus was on Cermak approaching State Street. Bus footage captured witness number three turning her head to the left to observe the incident between Mrs. Johnson, witness one, and the deceased. At that time, the deceased's white vehicle was seen on the bus footage with the driver's side door open. Witness three told officers she saw witness one pushing the deceased into the driver's side door frame and slamming the door on her. Witness three only observed the incident for 10 seconds before turning around. not making a threat or making a phone call, despite her telling the officers she did, right? Witness 3 then got off the bus with her baby stroller and began walking eastbound on Cermak, away from the incident and a few feet away from State Street. The bus stop is approximately 300 feet away from where the shooting took place. Let's bring this up again. I know I have showed you guys this multiple times. We're just going to go over it again quickly. Now, allegedly, okay, y'all know the third car up right here is where the incident took place. Homegirl got off the bus down here. Okay, let me go back a little bit. This is State Street, you guys, right here. Where this light is at. This street right here is State Street. That's going across, like left to west to, goddamn it, right to left. Left to right, okay? Left to right is State Street, okay? So she's traveling. She goes through State Street and gets off the bus here, right? At this stop right here, okay? Let's go a little further. Right here. So she gets off at this bus stop. Ari is saying, and let me pull it up because I want to read word from word. Now, I did not know this until today, okay? I did not know this until today because I actually thought when they had got it all mixed up with the Shark Tank cameras, Shark restaurant cameras, that that Shark camera is the one that caught witness number 3, observed her and her whereabouts. I'm finding out today, you guys, that it says her whereabouts were captured on the pod camera, okay? Not Shark's camera. So forget Shark's camera for a second. I know we went over that before, but forget Shark camera. Her whereabouts is seen on the pod camera, okay? So let's continue. It says at 0902, witness number 3 called 911 to report observing a fight breaking out with a white car and black car, 2 black females. She's also reported witness 1, Carlos, pushing the deceased into the driver's side door frame and slamming the door on her. After getting off the bus and walking away from the incident, witness 3 spun her stroller around. So again, this right here, when she got off at this stop, she advanced forward away from the incident, okay? And she crossed over all the way down here at this crossway. Then she turns around and start walking back the other way. Now, this is what's being shown or said to have been shown on the podcast. Now, why is this even important? Because the things that she say she saw and heard at the time she got off the bus is going to be kind of far-fetched given the fact that she got dropped off on a bus, advanced forward northbound, and then crossed the street and then started coming back this way. But as you're going to hear in Ari's write-up, and this is if we are to believe the defense, right? In Ari's write-up, Ari says the further that she got was behind this building. But let us keep reading, okay? So, are you guys following me? Are you following me? Okay. So, let me just, I'm gonna just put this out a little bit because I want you to see the crime scene. God dang it, Amor. Hold on. Damn it. The crime scene is down here, but she's down here. The furthest she got was behind this building at the time the shots was fired. Okay, now, let's continue because this is going to be important. So at 9:02, witness 3 called 911 to report. Okay, I read that. So after getting off the bus and walking away from the incident, witness 3 spun her stroller around. At 9:03, okay, just a minute later, A pod camera, not Shark's Restaurant, not the CTA bus, but the pod camera facing northeast at Cermak State intersection captured witness 3 crossing the east side of State Street walking northbound. Okay? So she is on the pod camera spotted at 9:03. Now at 9:02, she called a popo and said, hey, there's fighting breaking out with a white car and a black car between 2 black females, right? But at 9:03, she's caught on the camera all the way past the CTA station, okay? Now, it says once the witness crossed State Street, she was captured on that camera under the CTA green line. So let me show you where she was captured at after crossing over. She was captured under here, okay? Let's go back so you can see it a little further. So there's the crystals. She was captured here, you guys, here at 9:03, 16 a.m. A pod camera captured her here, okay? Now, 9:03, a pod camera facing northeast at Cermak intersection captured 3 crossing the east side of the state walking northbound. Within the incident occurring on the west side of the witness 3, witness was facing northbound. So right here it's saying the damn incident is happening back here, right? The incident is happening back here, right? Here's the incident. Let's continue. Third car, right? So the incident is happening back here, but she is caught on camera at 9:03 all the way under the CTA green line. Let's go back. Now, this is what Ari is saying. She was captured here at 9:03, okay? Now, once witness 3 crossed State Street, she was captured on a pod camera under the CTA green line, where she walked far enough north behind a building to have obstructed any westbound view of the incident occurring between Mrs. Johnson and the deceased. Now, what does it mean? She walked far enough. This is where she walked to, right here. She walked from all the way from over here, down here, across the street, and she walked over here. This is how far she got. Actually, they said behind this building right here is the farthest she got before she said, hey, Mima, it's Jordan. Look, my grandbabies are in here, y'all. Y'all, it is too early in the morning. It is 11:43. It's 12:43 where y'all at. Hey, babies, though. Hey, y'all. Y'all, tell my grandkids to go to sleep. I love y'all. Y'all got to get off my live, though. But I love y'all. Y'all can't be doing this every day. Where your daddy at? Where your mama at? But I love y'all. Mwah, 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 mwah. These are my grandkids. Lord Jesus. Love you, darlings. Love you, love you, love you. I love you. Girl, my grandbabies are stalking me. I'm going to have to get a stalking order. Houston said, go to bed, go to bed. No, I'm just kidding. But I love y'all, okay? But your mama, your grandmama, your mama. I ain't your mama, but your grandmama, your Mima is at work. Okay, I'm at work, but I love y'all. She said, hey, grandbabies. So anyway, so Ari is saying, she's talking about two precious. I know this is one and this is the other one. This is Mira. And then this is Jordan right here. Lord, Father God. Them my babies. I love it though. I love it. They done found my YouTube channel, child. You hear me? They done found my YouTube channel. All the grandbabies gonna have my YouTube channel. She talking about y'all gotta get blocked. Nah, I ain't gonna block my babies. I'm gonna call y'all tomorrow though. Me not gonna call y'all tomorrow. So Ari, the attorney, is saying the furthest she got, witness number 3 was behind this building right here. Okay, let's continue because it says that, okay, witness number 3 crossed State Street. She was captured on the pod camera under the CTA green line where she walked far enough north behind a building to have obstructed any westbound view. So basically they saying she walked far enough to get behind this building. So how in the world was she able to see the things that we about to tell you in a minute that she said she saw, okay? So it also goes on to say, and even if she would have walked southbound toward the state street and turned right to observe the incident, the pillar for the transit authority still obstructed her view, okay? So I'm assuming she means, let me bring that up. I'm assuming she means even if she would have came from out here, what pillar is she talking about? She said the pillar of what? Let me see, read that again. The pillar for the transit authority still obstructed her view. So I'm not sure what she mean when she say the pillar, unless she's talking about, I don't know what she's talking about, the pillar. I don't know what she's talking about when she says the pillar. Unless she's talking about this thing right here. But I don't think she would be talking about this thing if she's behind this building, because it's saying that if she would have came out and walked toward here, her view would have still been obstructed. Okay? So I'm not sure what she's talking about. Is she talking about right here or this little gray thing that says Chinatown? Maybe she's talking about this thing, but this is kind of, it's saying that if she would have walked out, this would have obstructed her view. I'm not sure how it would have obstructed her view if she would have walked out here and walked down there. I don't know how the pillar, but anyway, let me just continue to read it. I'm kind of a little lost on that one right there, y'all. So, but Ari says the pillar from the transit authority still obstructed her view. It says the pod footage revealed witness 3 run from behind the building where she and other bystanders are looking to the west of them. Okay? So, right here, she's saying witness number 3 ran from behind here and looked west. Okay? Now, this is at the sound of the gunshots, you guys. Let's continue because okay, let's continue. We'll get there in a minute. All right. So the pod footage reveal witness number 3 run from behind the building where she and other bystanders are looking to the west of them. And then at 9:04, witness number 3 called 911 a second time to report a shooting. Now, I want to go over that timeline again before we get into what she said she saw. All right? So let's go over the timeline, you guys. At 9:02 was the first 911 call where she said she saw them fighting, 2 black women, one in a white car, one in a black car. She didn't say fighting. Let me take that back because she didn't say fighting. She said she saw 2, they were into it. A white car and a black car, 2 black women were into it, okay? And she also said she saw Carlos slamming the door in Romika's back or into Romika's back, okay? That was at 9:02. At 9:03, just 52 seconds later, 52 seconds later, the pod camera shows that she was walking northbound, okay? Then the document, it said it does not give the exact time, but at 9:03 and before 9:04. So again, 52 seconds into her making the first 911 call and to her walking away from the scene. When I say away from the scene, I mean walking away, not toward, but away, meaning northbound. She was walking away at 9:03. So 9:02, 911. This is what I see. 9:03, she's spotted by the pod camera, still walking away from, not toward the crime scene, but away from the crime scene. That was just 52 seconds. Then at 9:04 is when she called the second time and said, there has been a shooting. Okay? So 1 minute and 39 seconds. This is what she said she observed. Okay? So again, she was supposed to be behind this building. The pod camera sees that she ducked her head out 52 seconds after. Oh, excuse me. Not 52 seconds. 9:02, she made a 911 call saying a white car and a black car that they were, it says, a witness 3 called 911 to report observing a fight break out with a white car and black car, 2 black females. That was at 9:02. 9:03, she's on the pod camera walking in the direction away from the incident, not toward the incident. 9:04, she called 911 and said there has been a shooting, okay? But the pod camera caught her ducking her head out, okay? It says the pod footage revealed witness 3 run from behind the building where she and other bystanders are looking to the west of them, all right? So again, let's break down what she claimed that she saw in a matter of a very, very short time, okay? So within those seconds, within a minute and 51 seconds total, this is what witness number 3 is saying that she saw, okay? She's saying she observed a fight. She called 911 the first time. She moved across the intersection. She walked north away from the crime scene. She crossed the street. She is having an obstructed view because now she is behind a building. She run from behind a building, looked down that direction. She called 911 again and said she observed a shooting. So, you guys, a minute and 51 seconds, okay? A minute and 51 seconds, but that's not what she said she saw. Let me tell you what she said she saw in the a minute and 51 seconds, all right? Not only that this will happen, but let's say what she said she saw. Again, she said in detail, after her first 911 call at 9:02, her first 911 call, she observed Romika, the deceased, enter her vehicle. She observed Holly approach the deceased vehicle making threats. Okay. She observed Romika exit the Kia and get placed in a chokehold by Carlos. She observed Holly allegedly go to her vehicle, retrieve a gun, and stand on the sidewalk. She observed the deceased, Romika, broke free from Carlos's chokehold and took steps away from Holly, while Holly pointed her gun while on the sidewalk at Romika and started walking forward and pow Romika. Now, but when speaking to the investigator the day of the shooting, witness 3 alleged that there was a pause after the first shot and subsequent shot. However, she told officers on the scene that the shots were successive, meaning rapidly, boom, 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 right behind each other, boom, boom, boom. But we're gonna get back to that part later. Let's get back to the they were rapid on the scene, but they were paused the day after, or the other way around. However, let's get back to that one. But now, what did we just say she observed? In a minute and 51 seconds, all the way down here by the CTA station, she was supposed to have observed Romika getting out of her vehicle, or should I say entering her vehicle first, Holly approaching her vehicle and making threats to Romika, Romika getting out of her vehicle, being placed in a chokehold by Carlos, wiggling out of the chokehold, but before getting out of the chokehold, Holly going to her car, getting a weapon, standing on the sidewalk, okay? Then she breaks free. She takes steps away from Holly. Holly, raise her hand, points her weapon at Romika, advance forward, pointing her weapon, and pow. All of that was supposed to be witnessed in 1 minute and 51 seconds, and the pod camera spotted her right here behind this building looking west. So she was supposed to have seen everything that she saw up before the shooting from here. You guys, can y'all see this? Now, I didn't know that. I had heard that that's what she was, and then all of a sudden they were like, oh, the short camera is off 35 minutes, so and I didn't know what was right or whatever, but this is what Attorney Ari is telling the appellate court, that at the time of the shooting, that she was right here. She didn't go no further. She is not on the pod camera at the smoothie station, which is right here, because that's what we was telling everybody, that she was at the smoothie station, which is right here, right? We was telling everybody that because that's what she said. That's what she said. She was at the smoothie station. And I'm thinking, oh, she at the smoothie station. She could probably have a little bit more advantage point. Not much, but a little bit more. But no. Ari is saying this lady didn't get no further than this damn wall at the time of the shooting. You guys. At the time of the shooting, she didn't get no further than this wall. So she was supposed to have observed all of what I just told you from all the way back here. She's on pod camera, not Shark's camera, not CTA camera, not nobody's phone camera, but the pod camera, the eye in the sky. And I say eye in the sky, but you know what I'm talking about. The pod camera, the police camera. I think somewhere over here in one of these little black boxes, what David was telling us or whatever, right? So that camera spotted her behind this building, okay? So let's continue what Ari says, all right? So again, 1 minute and 51 seconds. Now again, only 52 seconds from the time she called 911, the first time, to the second time, which is 9:03:16, 52 seconds later, she is walking northbound. She ain't even walking in the direction of the crime scene. 52 seconds later. So how was she able to see all of that shit again, you guys? How was she able to see all of what she said she saw if she's walking away from the crime scene? Mind you, she got a baby with her. She got a stroller with her. And she has headphones over her ears, okay? She crosses the street and she didn't get no further than behind this building. But she said that she was the one on the scene and saw everything, honey. All right, let's continue. All right, so again, let's get back to the document that Ari is submitting. Now, Ari is telling the appellate court that she has proof of all of this, okay? And the appellate court judge said, I want to see the shit. I want to see it, all right? That's what the appellate court is saying. The judge is saying. All right, so anyway, so now, witness 3 told the police that they saw all of that, right? So now Ari says, but when speaking to investigators the day of the shooting, witness 3 alleged that there was a pause after the first shot and the subsequent shot. Now, this is the day after the shooting. Now, I don't even know what would make a 21-year-old female say that there was a pause, okay? I don't know. Because then witness 4 came back and said the same thing, that there was a pause. My opinion only. I believe that those were words from the investigator, because I just don't think people would be like, oh yeah, and it was a pause and she did it again. However, I could be wrong. But at the scene, and this is the first time me seeing this, on body cam footage, Ari is saying that witness number 3 said that the shots were successive. And let me read exactly what successive mean when it comes to this. What does, hold on. Yes, please thumbs up this live stream. Thank you, Lavette. I'm going to let you hear what they say successive means, okay? When it's dealing with these shots, all right? I can't even believe that she would use those words, a 21-year-old. But I mean, you know, different strokes for different folks. But let's listen to what successive means. She told the police on the scene that the shots were successive. Now, I don't know if this is something the police asked or did she just volunteer up this information, but just listen up.
Great question. This word matters a lot for how the shooting is interpreted. What successive shots means. Successive equals one after another, quick quickly with no meaningful pause. So, successive shots use bang, 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 rapid sequence, simple breakdown. Successive shots, fired back to back, little to no gap, sounds like a quick burst. Not successive, shot, pause. That would be described as separate shots or shots with a pause. Why this word is important in your case. From the document, on scene, she said shots were successive. Later, she said there was a pause after the first shot. That's a direct inconsistency. Why it matters legally. Successive shots suggest rapid reaction, possibly panic or continuous threat, less time to reflect between shots. Shots with a pause suggest time to think, possible re aiming, potential escalation instead of reaction. Why defense cares? If shots are successive, easier to argue. It all happened fast. She reacted in the moment. If there's a pause, prosecution may argue she had time to stop. She made a second decision. Bottom line, successive equals rapid fire, one right after the other. No meaningful break between shots.
Okay. No meaningful breaks between shots. So on the scene, and again, this is the first time I'm hearing of this today. On the scene, on the body cam footage, witness number 3 said that the shots were successive. The next day, in the investigative interview, she said that there was a pause between each shot. So Ari pointed that out to the appellate court because, she's saying this witness is jacked up, ate up from that she ain't see shit, that she's not credible. So that is one thing that she identified. She said one thing at the body cam footage and said something totally different during the investigation. Okay. Now, she also claimed that witness 1, which is Carlos, and Holly fist bumped after the shooting, though this was never stated to officers on the scene. So again, Ari is stating on body cam footage of the officer, she never brung up a fist bump for a celebratory, but yet at the interrogation, not interrogation, I keep saying that, but the investigation, she mentioned they fist bumped. There was a fist bump. And if I'm not mistaken, she said it like 3 or 4 times, okay? Not sure who put that in her head or why would she say that or whatever, but she didn't say it at the scene, but she said it at the investigative room. Now, that's all she put for witness number 3. I'm going to go further and tell you what she said about number 3, but let me go over witness number 4 statement first, and then number 5, and then we're going to go and tell you what she said about number 3, all right? So witness 4, this is the school crossing guard. He was walking east on Cermak approaching State Street. He alleged that the deceased, Romika, was unarmed with a handgun in the air. Unarmed with her hands in the air, trying to break free from witness 1 grasp. Witness 4 turned away from the incident while the shots broke out. So basically, he's saying he didn't see nobody shooting nothing. He was already turned away, wasn't paying it no attention, okay? But when he heard the shots, he turned around and he saw Holly with the black handgun in his right hand, okay? Now, we all know, we have heard other video footage of, but we're just going to talk about what's in the document today. We're just going to talk about what's in this document. So scratch what I just said. So again, witness 4 turned from the incident while the shots broke out, but when he turned back around, he saw Mrs. Johnson with the handgun in her right hand. Witness 4 identified Ms. Johnson as the shooter after assuming that because she had a gun, she must have fired the shots. Okay, that's witness number 4. Now let's get to witness number 5. It is alleged that witness 5 was in the car and then watching from her workplace on Cermak when she saw the deceased and Mrs. Holly arguing on the streets over witness number 1. She alleged that the deceased was not aggressive, meaning Romika was not aggressive, and that Holly was charging at Romika, prompting Carlos to grab Romika to stop the fight. Witness 5 alleged hearing Holly state that she was licensed to carry. Witness 5 claimed to hear 4 shots. Now, of course, defense attorney Ari has to put all witness statements in here. She summarized them. This is not the full statements. This is just a summary of the statement, but she has to give it to the appellate court because this was used for the judge to make his decision to keep Holly detained. Okay, now, of course, you guys, let me just say this. This is not the entire statement of none of the witnesses. Okay, this is just a summary that was used in the proffer or in court to keep Holly detained. So Ari had to put those in here. Now she goes on to procedural facts. Okay. On December the 3rd, 2025, Holly was arrested. On December the 4th, a detention hearing was held for Holly. The court ordered her to be detained. A motion for relief pursuant to the Illinois Supreme Court rule was filed on December the 22nd. An amended motion for relief was filed on January the 7th. On January the 8th, the Honorable Judge Michael Clancy denied Mrs. Johnson amended motion for relief. The same day, Holly filed a notice of appeal from the pretrial detention order. All right. Now that's just facts of what happened. Now here comes the argument. Y'all take a sip. Take a sip of water. Take a sip of water. Feel free to tip the host. Feel free to tip the host. Throw some love. Let's take a break, you guys. I'm gonna take a break about 20 seconds or so. You guys can tip the host. Hold on, let me put some music on. I don't know what music I'm gonna put on. What music I'm gonna put on, y'all? Here, we're gonna put some music on. You guys can tip the host. Okay, we back. I had to eat me a cracker with some tuna. All right, you guys, let's continue. Thank you guys for those that threw your girl some love. Thank you for the love. Like my grandbaby say, thank you for the love. Appreciate you. All right, so let's continue. Where we at? We are now. We're gonna start with the argument, you guys. Cause listen, Ari had some shit to say. Ari had some things to say. So now we are at the argument. Ari says the court should reverse the trial court order to detain Mrs. Johnson. Okay. She says the court should reverse the trial decision to keep Holly detained because the state failed to prove its burden by clear and convincing evidence. The issue presented as to the trial court's detention decision is subject to this court independent de novo review, Peoples versus Morgan. So what she's doing, she's taking her case and she's pulling up another case to show reference, and she does this quite a bit throughout her argument. Okay, she used different cases to argue her point of, listen, this case right here y'all did it, 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 so there is no reason to keep Holly detained. Now let me pause for a moment before I continue on. Okay, let me put this up to let you guys see first of all, and then we're going to talk about this a little bit further, because I want to get one thing straight, because I know I just know it, I just have a feeling, I got a feeling somebody's gonna say, what do you mean it was convincing? Listen, this is going up to the appeal court, basically saying that Judge Clancy got it wrong. So for anyone to reference back to what Judge Clancy said on December the 4th, right? And he showed where he came up with the clear and convincing evidence. Ari is saying the judge got it wrong, okay? So for them to even be still showing that, to say, no, he didn't, this is what he said, that does not mean he didn't get it wrong. Now, I'm not saying he got it wrong, because it's up to the appeal court to say if he got it wrong or not. If I have to put my spin on it, yes, I do believe he got it wrong. I do not believe that Holly is a threat or danger to the community. Hence, she was out for 87 days. If she was a threat or danger to the community, then something else would have popped off in those 87 days that she was not detained, okay? However, Attorney Ari is saying the court should reverse the trial court's decision to keep Mrs. Johnson detained because the state failed to prove its burden by clear and convincing evidence. The issue presented as to the trial court detention decision is subject to the court's independent de novo review. Now, I don't know what de novo means. Let me find out right quick what de novo means, okay? Hold on, let's find out what that means right quick. De novo. Is it de novo? Oh, no, de novo. Okay. Okay. Let's find out what it means. Okay. All right, let's hear it. I want y'all to hear it. I don't want to have to read all of this, so let's hear it.
Great question. This is a key appellate term, and it actually matters a lot for how strong the defense's appeal is. What de novo review means: de novo was from the beginning. So, de novo review equals the higher court looks at the issue fresh with no deference to the trial judge. Simple explanation. Instead of saying, open quote, let's see if the trial judge made a mistake, close quote, the appellate court says, we're going to decide this ourselves like it's brand new.
Oh, okay.
What that means in practice: the appellate court does not have to agree with the trial judge, does not give weight to the trial judge's decision, can completely replace the decision. In your document, the defense says, open quote, the detention decision is subject to de novo review, close quote. That means they're arguing the appellate court can reevaluate everything independently. The trial judge's denial of release does not get special protection. Why this is important for the defense: this is actually good for the defense because They're not stuck with, did the judge abuse discretion? Hard to win. Instead, the appellate court can say, we disagree completely and in reverse. Compared to other standards, de novo, what you have here, fresh review, no deference, best chance to win appeal. Abuse of discretion, judge gets leeway, harder to overturn. Clearly erroneous, very hard to overturn. Bottom line, de novo review equals the appellate court decides the issue from scratch without relying on the trial judge's decision. What that means for your case. The appellate court can reevaluate the evidence, reassess credibility issues like witness 3, decide whether detention was justified, and they can reverse the decision completely.
Okay. So, did we just learn what de novo means? It means fresh look. So, they do not have to consider at all what Judge Clancy wrote up on December the 4th. It has no bearings on their decision. Okay. It's like fresh eyes. I don't give a hell what, the judge said or whatever. We're looking at this as fresh set of eyes, and we're going to decide this ourselves like it is brand new. Okay, that is what Ari is arguing. Now, this is not what the appellate is doing. This is what she's saying. Okay, the court should reverse the trial court decision to keep Ms. Johnson detained because the state failed to prove its burden by clear and convincing evidence. This issue presented as to the trial court detention decision is subject to this court's independent de novo review. People versus Morgan. So she's saying this issue presented as to the trial court's decision is subject to this court independent review. Okay, meaning that you guys need to look at this as fresh eyes. So with that being said, it seems like they're going to be looking at it without the input of what Judge Clancy's already stated. Okay, the trial court's ruling to keep Mrs. Johnson detained during her trial amounts to reversible errors where the state has failed to prove by clear and convincing evidence that the proof is evident and presumption is great that Mrs. Johnson committed the offense of first degree murder. Mrs. Johnson posed a real threat and present threat to the safety of a person or the community, and there are no conditions or combination of conditions that can mitigate the real and present threat posed. Now, when I first saw this, I was like, like it says that there is no clear and convincing evidence that the proof is evident and presumption great that Mrs. Johnson committed the offense of first degree. And then I was thinking, well, she admitted to the shooting, right? However, if you zoom in on what it's saying, it says they failed to prove, and this is large. Actually, this is deep. This is a lot. The state failed to prove by clear and convincing evidence that she committed first degree murder. Okay? Which means that if it is clear and convincing evidence that she committed first degree murder, is saying that there's other options out there. They have not convinced clear and convincing. They have not given clear and convincing evidence that she committed this. It was a murder. It could have been self-defense. It could have been a manslaughter. It could have been whatever the hell, but it's not clear and convincing evidence of first degree. Okay? Because it says here, committed the offense of first degree murder. All right? And also, it says that there is no clear and convincing evidence that she posed a real and present threat to the safety of a person or the community, and there are no conditions or combination of conditions that can mitigate the real and present threat. Now, it goes on to say, the state failed to prove by clear and convincing evidence that the proof is evident and presumption is great that Mrs. Johnson committed the offense of first degree murder. And she highlighted that. Why did she highlight that? Because basically she's saying that the state think they didn't prove their case. The state think that they done submitted enough evidence to prove that this was first degree. That she intentionally, maliciously unalived Romika, because that's just what her mindset was. That's what she intended to do. The defense is saying, hold up now. No. Wait a minute. You ain't proved that. And she's going to go a little further and say that they have just totally disregarded some of the important evidence in this case, i.e., the TPO, i.e., the threats, i.e., her son was on the scene, i.e., Romika was the aggressor, i.e., Romika pulled up on them, i.e., they was minding their own damn business, going about their day, i.e., witness number 1 said that Romika ran up on her, i.e., witness number 3 is not credible, i.e., witness number 3 is the one that gave y'all all of this information, and witness number 3 was hiding behind a building when the shots rang off. So, i.e., y'all ain't proved nothing, okay? Oh, okay. You right. How you say your name? I don't know how you say your name. Let me see. It's Ronisha? Ronish? Is that how you say your name? Ronishara? Can you break it up for me so I know how to say your first name? Thank you, baby. I read your comment. So Ari is saying, hold up now. You ain't proved that. Because if this the case, then she don't need to be paying me all these hundreds of thousands of dollars. And we don't need to be having a trial. And we don't even need to enter self-defense, because the state is basically saying that they have evidence and, clear and convincing evidence that there is a first degree, murder. And she said, no, y'all ain't proved that. Nisha's fine. Okay, thank you, Nisha. Appreciate that. So Ari is pushing back, okay? And I like the way she bolded it, highlighted it, like, nah, y'all need to come again, because this is not convincing, all right? So then she goes on and say, in the state of Illinois, monetary bail has been abolished. All persons charged with a criminal offense shall be eligible for pretrial release before a conviction, meaning they should be eligible unless some other circumstances take place. The court must hold a hearing and make required writing findings. At all pretrial hearings, the state bears the burden of proof to prove by clear and convincing evidence that any condition of release is necessary. A court may order a defendant detained pending trial if the defendant is charged with an innumerate detainable felony offense found in whatever that statute is of the act, and if that defendant posed a real and present threat to the safety of, and let's just look up what enumerate means, because I don't know, y'all. Listen, we gonna learn together. What is it? How you say it? Enumerate. Okay, hold on. Enumerate means, okay, let's see what it means. No, I think I spelled that wrong. Enumerate. Okay. Something that has already been clearly listed or specified in details. All right, let me go back to it. It says, a court may order a defendant detained pending trial if the defendant is charged with an enumerate detainable felony. Okay, well, what in the world would that mean? Let's find out what this means. Enumerate detainable felony offense. Oh, so enumerate means specifically listed in the statute law, not just a crime, not just any old crime, but only those that are in this that's named, okay? And so which ones would they be? Let's find out which ones will they be. Okay, so in the state of Illinois, it says, okay, I'm gonna let it tell you what it says right here. Hold on. Let's get to it. Hold on.
Good. This is a very specific legal phrase, so let's break it down precisely. Enumerated detainable felony offense.
Enumerated.
Full English. It means, open quote, a felony that is specifically listed in the law as one that allows a person to be held in jail, detained before trial, close quote. Breaking the phrase apart. 1. Enumerated specifically listed in the statute law, not just any crime, only the ones the law names. 2. Detainable, eligible for pretrial detention, meaning the person can be held in jail instead of being released while the case is pending. 3. Felony offense, a serious crime, not a misdemeanor. Put it together. Enumerated detainable felony offense equals a serious crime that is specifically listed by law as one that can justify keeping someone in custody before trial. In Illinois law doesn't allow detention for every felony. Only certain ones are enumerated, like first-degree murder, forcible felonies, gun-related offenses, domestic violence, in some cases, stalking, etc. Why this matters in your document. The state has to prove the charge is an enumerated detainable offense, and also, 1, proof is evident, presumption great. 2, defendant is a danger or flight risk. 3, no conditions can mitigate that. # defense strategy. If the defense is talking about this, they may be arguing the state didn't properly prove it fits an enumerated category, or even if it is enumerated, the other requirements weren't met. Simple version. Enumerated detainable felony offense, a specific serious crime that the law says can justify holding someone in jail before trial.
Okay. So, simple version, enumerated detainable felony offense, a specific serious crime that the law says can justify holding someone in jail for a trial. So, first degree is considered an enumerated offense, right? First degree is. However, there are still restrictions that can be looked at, all right? Restrictions like house confinement, supervision, monitoring, ankle bracelet, and things of that nature or whatever. So that can be looked at as well. So it says a court may order a defendant detained pending trial if the defendant is charged with an enumerated detainable offense found in this statute 110.6-1 of the Act, and if the defense pose a real and present threat of the safety of the community. Okay, let's go to the next one. However, I know we have heard that you cannot have a first degree murder and get let out, and that is not true, because we looked it up and there are several people that was charged with first degree that is walking free. Okay? That is walking free, that they are not locked up right now while they are going through their trial. So again, it says, hold on with the argument. Okay, so it says of the Act. Okay, so enumerated detainable offense found in the statute of the Act, and if the defendant pose a real and present threat to the safety of a person or person in the community. And then it lists Roe versus Royale. All right. So she did that throughout this document, stated different cases, case studies that, that she used. Okay. So when pretrial release should be denied to a defendant on the grounds that they pose a real and present threat, the state has the burden of proving that claim based on the specific articulable facts of the case. Here, the state failed to prove that by clear and convincing evidence, that the proof is evident and presumption is great, that Mrs. Johnson committed the offense of first degree. Again, she keeps highlighting of first degree. Y'all ain't proved that. Y'all have not proved that she committed first degree, is what Ari is stating. Hold on, let me get back to this. She's saying y'all have not proved that she committed first degree. So then it goes on and say, in Illinois, a person is justified in the use of force against another person, when and to the extent necessary that they reasonably believe that such conduct is necessary to defend themselves against another. Such other intimate use of, let me read that again. In Illinois, a person is justified in the use of force against another when and to the extent necessary that they reasonably believe that such conduct is necessary to defend himself or another against such other intimate use of lawful force. Right here, she's not saying just defend themselves. She said, or of another person, because she's trying to say, i.e., her son. All right. Now, here we go. On September the 8th, 2025, Mrs. Johnson was justified in her use of force against the deceased, who was looking to incite violence against her. Mrs. Johnson, accompanied by her boyfriend and their 6-month-old child, were going on with their day after spending the entire weekend together. It was the deceased, Romika, who approached Holly and Carlos on 20 West Cermak and blocked Holly's vehicle with her white Kia after completing a U-turn. It says record 78, record 110, record 120, and 21. So I'm assuming that she is telling the judge, boom, here's proof. Because I heard that there was proof, okay? So it looks like she may be showing that there is proof. The deceased dropped her and Carlos's 6-year-old son off at school across the street prior to approaching Mrs. Johnson. The deceased was initially driving eastbound on Cermak, but she ended up with her vehicle parked westbound on Cermak across the street from her child's school. So basically they saying she was driving forward until she busted a U-turn and ended up facing in the opposite direction, okay? Meaning, let me explain to you what that means. If she was driving east and ended up going west, that means she deliberately turned around, pulled up, and parked. It wasn't by no coincidence. It wasn't like she was just driving and ran out of gas or saw a lemonade stand and said, ooh, can I buy some lemonade? She intentionally pulled up is what they were saying, okay? Now, although this encounter was the first time that Mrs. Johnson and the deceased saw each other in person, the deceased had continuously threatened and harassed Mrs. Johnson. Record 5, record 142 and 143. Amongst those threats, the deceased found Mrs. Johnson's grandmother's phone number to mention her desire to KI Mrs. Johnson. Mrs. Johnson petitioned for the stalking no contact order against the deceased. She was fearful for her life and fearful of this individual, reasonably believing that the deceased would follow through on the threats made to end her life. Okay? Similar on September the 8th, 2025, Mrs. Johnson once again reasonably believed that the deceased would inflict imminent death or great bodily harm against her. The deceased willingly and uninvitedly approached Mrs. Johnson in an aggressive manner. She blocked her in with her car and made it physically impossible for Mrs. Johnson to leave the area. And the deceased physically attacked Mrs. Johnson. Record 158. Witness 1 stated to the police on the scene that the deceased Romika ran up on Mrs. Johnson and swung at her. Record 150. Mrs. Johnson was absolutely attacked by the deceased Romika, also exhibited by her appearance before and after the incident. Record 162. So right there, she shows a photo. It says exhibited by her appearance before and after the incident. So I'm assuming that she showed a before and after photo of Holly. It says where video footage prior to the incident showed Mrs. Johnson with tidy hair. Mrs. Johnson's hair was completely disheveled once the police arrived on the scene. 162. So that record 162 must mean that that's the picture of what she looked like when the police arrived on the scene versus there's video footage of Carlos, Holly, and baby Carlson coming out of Carlos' apartment, walking down the stairs, getting into their vehicle in the alleyway. In that vehicle, Ari is saying Holly's hair is notably tidy. She pulled it back in a nice ponytail or whatever. But after the fight, and once the police arrived at the scene, her hair was disheveled. So Ari is showing before and after footage of what Holly's hair looked like, okay? Now it goes on to say Mrs. Johnson being physically attacked by the deceased is also corroborated by the 911 call made at 9:02 from an unknown caller who was on the scene on September the 8th, record 91. This unknown witness reported to the 911 22nd and State across the street from the school. There are two black women fighting. Record 115. The witness confirmed that two women were hitting each other. Record 115. I would love to hear that recording. I think that's the one that we did here. She continues with, there's a black lady. She seems to be the aggressor. And then she goes to talk about the one with the gun who has the green on. Rather than stating that the woman with the green, who is Petitioner Holly, was the aggressor, Petitioner Johnson was the aggressor. I think she mean the defendant Johnson. I think she messed up right there. Oh, petitioner meaning petitioner in the TPO. Okay, never mind. Rather than stating that the woman with the green, Petitioner Johnson, was the aggressor, the witness separated Miss Johnson as simply being the one with the gun wearing a green two-piece tracksuit. The witness illustrated the black lady who seems to be the aggressor as the deceased who had dark skin. Okay? So again, the caller used very descriptive language. She first started off saying there are two black women fighting, and then she divided the women by saying the black lady seems to be the aggressor, but the one holding the gun is in the green tracksuit. Okay? This is what Ari's saying that she has a recording of. All right? Now, let's continue. The numerous accounts undoubtedly prove that Mrs. Johnson was physically attacked by the deceased, directly contradicting the inconsistent and unverifiable observation from witness number 2, witness number 3, witness number 4, and 5. She discounted all they asses. Witness number 2, for instance, did not observe the actual shooting since he was inside of a coffee shop within the vicinity. Witness number 3 cannot even be deemed credible. Good Lord, Father God. She just flat out said, witness number 3 cannot be deemed credible, where there are various inconsistencies in her statement. Now, I'm going to put this up. We're going to read this one right here. I'm going to put this one up because I want y'all to read this one with me. I do. Because I've been saying this for the damn longest, honey. And I ain't even no attorney, baby. I need to be. I really do. But let's put this up and let's read this together. What Ari is straight up saying, no hesitation whatsoever. Okay? Let's start here, you guys. Where she talks about witness number 3. Witness number 3 cannot even be deemed credible, where there are various inconsistencies in her statement. On the scene, witness 3 recounted there were 5 shots in succession, while the next day she told the officers that there was a pause. Now, she said there were 5 shots in succession, meaning rapidly, one after the other. Bang, 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 bang. But the day later, she told officers there was a pause after the first shot. While traveling eastbound on the bus, She observed the incident between all three parties for only 10 seconds and did not dial 911 until after she exited the bus. They have her on video, y'all. They got her on video. She claimed to hear Mrs. Johnson threaten the deceased while traveling on the bus since the bus window was open. However, not only was the window closed, oh Lord, she ain't tell them it was open, did she? It says she claimed to hear Miss Johnson threaten the deceased while traveling on the bus since the bus window was open. But Ari has done her job, and she didn't have an investigator to go find out that the window wasn't even open. It was closed. She's a liar. She's a liar. But nevertheless, we're going to say inconsistent. All right. We're going to use the word inconsistent because Ari is not allowed to call her a liar, but Amore is. Amore is allowed. Nevertheless, she claimed to hear Mrs. Johnson threaten the deceased while traveling on the bus since the bus's window was open. However, not only was the window closed, but witness 3 also wore thick wireless headphones over her head. Record 73, 75, and 83. She had to remove those same headphones when speaking to the police on the scene, suggesting impaired hearing with the headphones on. Record 73. Once off the bus, witness 3 walked eastbound away from the incident. She wasn't even walking toward the direction of the damn incident. She proceeded to cross the busy street of Cermak, walking and facing northbound and not toward the incident on the west of Cermak. She wasn't even facing them at the time the incident took place. So she wasn't, listen. She proceeded to cross the busy street of Cermak, walking and facing northbound and not toward the incident on west of Cermak at the time the incident took place, which means she wasn't nowhere around. I kept telling y'all that lady didn't see what she said she saw. She's a liar. Nevertheless, witness 3, witness three's view of the shooting was also obstructed by the CTA Green Line building, okay? Where she was captured. Hold on, where my little thing at? She was captured on the pod camera, not the Sharks camera, not the CTA bus footage camera at this time. She was on the pod camera. This is some type of police device camera, okay, y'all? Emerging from behind the building only after other bystanders noticed the incident. The girl was ducking and came from behind the building only after other bystanders noticed the incident, which occurred 350 feet away from them. She was nowhere near the crime scene, you guys. Record 83, 105, 112, and 13. Don't you love some good old receipts? Now, of course, we don't see them right now. I don't even know if we will before court. Probably not. However, Ari is saying, we got proof, baby. We ain't just talking noise. We got proof that witness number 3 was nowhere around. Now, she goes on to witness number 4. Witness number 4 also did not observe the actual shooting since he was facing away from the incident, turning around only to see Mrs. Johnson with a black handgun in her right hand. Similarly, I can't even say that word right. If I say it, anyway. Witness 5 is not credible. So now she's saying witness 3 ain't credible, and she's saying witness 5 ain't credible either. All right? She said witness 5 is not credible, where she allegedly watched the incident from inside the lobby of her workplace on Cermak, record 154. Her view would have absolutely been obstructed not only from the distance between the incident and her workplace, but also from any parked cars and trees on Cermak. Now, we don't know, the public, meaning I, you, and other folk, don't know where she worked. But guess who does? Ari knows. Ari knows and the prosecutor knows where she worked. And Ari says here, her view would have absolutely been obstructed, not only from the distance between the incident and her workplace, but also from any parked cars and trees on Cermak. Baby, she said witness 3 and witness 5, they share some similarities. Both of their asses are not credible. She says that about witness number 3. Witness 3 cannot be deemed credible, and witness 5 cannot be credible. All right? Now, the account relied on by the state to conclude that, okay, let's go to the next one. Hold on. Let's go to the next one. Let's go to the next one. Ari ain't playing, and I love it. Ari ain't playing, and I love it. All right, so she says, hold on. Thus, the account relied on by the state to conclude that Mrs. Johnson committed the offense with which she is charged are heavily unverified, speculative, and not credible. So basically, she's saying witness number 2, witness number 3, witness number 4, and witness number 5 ain't seen her do nothing. They didn't see it. They didn't see the shooting. They heard it, but they didn't see it. And she says, why witness 2 didn't see it? Because he was driving DoorDash. He admitted he was in a coffee shop when the shots rang. He didn't see no shooting. Witness 3, her ass wasn't nowhere near it, child. She ain't see nothing. Witness 4, he admitted he was going in the other direction. He didn't see anything. And witness 5 can't be credible either. Where she work at, we don't know, but Ari does. Ari said the distance and the trees and the cars, nah, she ain't credible either. So Ari just discounted all 4 of the state witnesses, saying they can't prove that this was first degree. Okay? Then she goes on to say, so anyway, I think I was on, what was I on? Hold on, let me just think, where was I? I think I was on how Ari just kind of broke down how witness number 2, 3, 4, nor 5 saw Holly do anything. So they cannot say it is proof, evidence, or, whatever. The evidence is great that she committed a first degree M word, right? And the reason being because they didn't even see her do it. They didn't even see her pum pum, so they don't know what happened right before the pum pum. And she basically just said that witness 3 and witness 5 ain't credible at all. And I'm loving this because those are the 2 that has the state thinking that they really got this in the bag, okay? So I'm glad that she's already saying it not credible because, baby, we gonna have something to look forward to come trial time, okay? We're gonna absolutely have something to look forward to during the trial. So let's continue, okay? Let's continue. She just said 5 weren't credible. So then she says, so it says Mrs. Johnson use of force was reasonable, and the mere fact that multiple shots were fired do not negate the claim of self-defense. And then it says People versus Davarinu. How do you say that? Okay. People versus this D word, right? Deciview or something like that, right? So she just dropped another case law that says just because there are multiple shots does not mean it negates the claim of self-defense, meaning that does not mean that it's not self-defense here, And then she goes on to say, further, previous courts have determined that first degree charges are insufficient to sustain pretrial detention. See People versus Miller. So meaning that just because she is charged with first degree does not mean that she cannot be released. That's not what that means in the state of Illinois. People versus Miller. Apparently, this is a case that happened in 2024 where this person was accused and charged of first degree and they were still released from detention. So she says, as such, the state failed to provide by clear and convincing evidence that Mrs. Johnson committed the offense of first-degree M-word. The state failed to prove by clear and convincing evidence that Mrs. Johnson posed a real and present threat to the safety of a person, persons, or the community. Then she goes on to say, the state failed to prove by clear and convincing evidence that Mrs. Johnson posed a real and present threat to the safety of a person or the community. A court may consider factors articulate in addition to the specific articulable facts of the case when determining whether a defendant posed a real and present threat to the safety of a person. It says Mrs. Johnson is a 31-year-old pregnant woman and a current mother of one. She has lived a very law-abiding life. Mrs. Johnson ran a successful lucrative lash business and earned acceptance into a school to become a dental assistant. Besides misdemeanor conviction, one of which was a traffic conviction, stemmed from over 10 years ago when she was 21, Mrs. Johnson has not been arrested, charged, nor convicted of any violent crimes. Mrs. Johnson is not a person of violent character. In fact, Ms. Johnson has been readily compliant with law enforcement and subsequent investigation into this case. Since the incident took place, while on the scene, Mrs. Johnson did not flee nor evade arrest or prosecution. Most notably, Ms. Johnson spent approximately 87 days outside of the custody from September the 8th, 2025, until she was arrested and charged on December the 3rd of 2025. During those 87 days, Mrs. Johnson did not reoffend, nor did she attempt to leave the state of Illinois. The record is completely devoid of evidence, and I agree, devoid of evidence illustrating that Mrs. Johnson poses a real and present danger or that she would fail to comply with any court-imposed orders or conditions. Further, a finding of dangerousness alone does not automatically warrant pretrial detention. People versus Martinez Ortiz, okay? Another case law. I'm loving the way she's dropping these case laws like, boom, this case had this going on. Boom, this case had this going on. Boom, this case had this going on. So why you holding my client again? Subsequently, the facts that a person is charged with a detainable offense is not enough to order detention, nor is it enough that the defendant poses a threat to the public safety. People versus Atterbury. So in 2023, Atterbury had a case with the state of Illinois where they tried to say that person committed a detainable offense, okay? And that person was a threat to the public and they were released on detention, okay? Same. They were charged with first degree and they were considered a threat to the public, but they were released. Because why? A detainable offense is not enough to order detention, okay? I'm believing that Mrs. Johnson was emboldened by her CCL. The state in believing, because the state said they believe that. In believing that Mrs. Johnson was emboldened, okay? Had courage, got bold, got courage, thought that, by her having a CCL, she had the rights to do this, right? In believing that Mrs. Johnson was emboldened by her CCL, the state completely overlooked and ignored the intimate threats and great bodily harm that the deceased imposed on Mrs. Johnson on September the 8th of 2025. The fact that the deceased was unharmed does not negate the incredible and intimate danger that she imposed on Mrs. Johnson, nor does this fact negate that the deceased was indeed the aggressor on September the 8th, 2025. In fact, under the Illinois law, where it is clear that the aggressor is capable of inflicting seriously bodily harm on the defendant without the use of a weapon. And it appears that he intended to do so. I think she means she intended to do so. Then it is not necessary that the aggressor be armed for the defendant to employ deadly force in self-defense. People versus Evans. So basically what she's saying here is just because Romika did not have a weapon, right? Just because she did not have a weapon and that she was the clear aggressor. So right here, Ari is saying, under the Illinois law, where it is clear that the aggressor is capable of inflicting seriously bodily harm. So she's basically saying it's clear. Ain't no doubt about it. It's clear that Romika was the aggressor. So she said, where it is clear that the aggressor is capable of inflicting seriously bodily harm or the defendant without the use of a weapon, and it appears that he intends to do so, then it's not necessary that the aggressor be armed for the defendant to employ deadly force, meaning that she does not have to have a weapon for the defendant to defend themselves, okay? People versus Evans, right? Then she goes on and say, here the deceased went to the car, but came back to attack Mrs. Johnson, leading Ms. Johnson to believe that deceased was coming back to cause great bodily harm based on the previous threats made to KI her. So Ari is saying here, yep, things calmed down. She didn't say that, but she said Romika went to the car and then she came back. Let's read that part again. Let's go back to that part. Here, the deceased Romika went to her car but came back to attack Miss Johnson, leading Miss Johnson to believe that the deceased was coming back to cause great bodily harm based on the previous threats made to her. Because why else was she coming back? Why else was she coming back? She got in the car, right? What she go to her car and come back for? Because she wasn't done. She came there for a purpose, and her purpose wasn't completed, okay? Now let's continue. Essentially, it is exceedingly clear that Mrs. Johnson is not a threat to the safety of any person or the community. And the state failed to prove that by clear and convincing evidence that Mrs. Johnson posed such an alleged threat. This court should reverse the trial court order of detention. The state failed to prove by clear and convincing evidence that there is no condition or combination of conditions that can mitigate the real and present threat posed. She says the state bears the burden of providing by clear and convincing evidence that no conditions or combination of conditions that can mitigate the real and present threat to the safety of a person or the community, right? She goes on to say there are various factors a court shall consider when determining which conditions of pretrial release, if any, will reasonably ensure the appearance of a defendant as required, the safety of any other persons or the community, and the likelihood of compliance by the defendant with all of the conditions of pretrial release. The conditions of release imposed shall be least restrictive conditions, all right? In the present case, the state relied on the nature of the offense to disregard any consideration of least restriction means outside of detention, only going to the extent of stating that there are no conditions or sets of conditions that this court can pose that would mitigate the risk this defendant would pose to individuals and the community as well, especially given the specific facts of this case. The trial court itself also refused to impose electronic home monitoring based on the nature of the offense where multiple shots were fired. And because electronic home monitoring cannot respond in real time to protect someone who is reacting to a volatile situation. Importantly, the nature and the circumstances of the charged offenses is just one factor to consider in determining whether the threat poses can be mitigated by conditions of release. People versus Lopez, 2025. The court in Atterbury also made it clear that one relevant consideration is whether there is reason to believe the defendant is likely to violate the condition the court might impose. However, a court should not rule out pre-release for a defendant based on a general perception that conditions of release are loosely monitored. Atterbury at 18. Okay, she just did another reference or whatever. So this trial court here, similar to the court in Peoples versus Mija, whatever, disregarded all the evidence showing that Mrs. Johnson would comply with this order, setting conditions on her release, and ordered defendant detention based solely on the bare allegations underlining the instant complaint. People versus Mijaya, or I'm just gonna say me. The court in me reversed and reprimanded for a new hearing regarding the defendant condition for release. So basically, she's saying here, this went up to the appellate court. People versus Majia, Mejia, Magia. So in the case of People versus Magia, it went up to the appellate court, and the appellate court reversed and reprimanded for a new hearing regarding the defendant's condition for release. All right. In this case, because they tried the same thing, right? They disregarded all the evidence and they just focused on basically the crime, what she did, all right, and the complaint of what she did. So they just looked at the complaint. They didn't look at nothing else, right? So even then, other alternatives to detention enumerated within the Pretrial Fairness Act were not considered, such as refraining from possessing a firearm, refraining from going to a certain geographical area, being placed under direct supervision of the pretrial service agencies, et cetera, et cetera, et cetera. So People versus Carter. So basically, Ari is saying the judge didn't consider shit. Nothing. No monitoring, no supervision, no restraining order. You are limited to this area and this area only. They didn't consider nothing. They basically said, ain't no conditions out there. We're gonna even initiate for you because we just believe that you are a danger, period. We ain't considering nothing, is what Ari is arguing, okay? So then she goes on to say, consideration of Mrs. Johnson's age, prior employment, lack of her criminal history, lawful gun possession, her family life, and lack of violent behaviors are relevant in determining whether imposing conditions of pretrial release would actually help mitigate any alleged threat posed. And such criteria should have meaningful consideration in the case at hand. People versus Lopez. In conclusion, Ari is saying the state has failed to prove its burden by clear and convincing evidence to keep Mrs. Johnson detained. And this court should reverse the trial court's order to keep Mrs. Johnson detained pending trial. Wherefore, defendant appellate, Kadasia Johnson, respectfully requests that this honorable court vacate the trial court order for pre-trial detention. That is what Ari is basically telling the courts, okay? Now, what do y'all think? We done. We are done with the 18 pages. It's really 16 because the last two is just procedural admin type stuff. So we are done with the 18 pages. Now, of those 18 pages, I believe Ari did an excellent job laying out that the appellate court should reverse their decision. Now, I really believe that it will be reversed. I really believe that Holly will be sent home, okay, pending her trial. simply because she noticed a lot of things. One, that the state witnesses are not that credible. They didn't see what they say they saw, right? But not only that, she also proved with all of these case laws that other people charged with the same thing, first degree murder, is out fighting their trial. So how can you let them out and not let Holly out? Holly doesn't have criminal behavior, violent behavior. And she also says that the state overlooked the fact that Holly was being threatened by the defendant. The deceased. Holly not only was being threatened by the deceased, but the deceased was the aggressor. She's the one that pulled up, okay? All right? Ari haven't even told everything she knows. This case going to be a shocker. Yeah, Ari has not, and this is not all the evidence. She didn't even put. Now I will tell you. Let me read what the courts did come back and say. Hold on one second. Let me read that part because that's important as well. So the courts did respond, right? And this is what they said. Give me a second. So the courts did respond, and this is what they said. Let me put this up for you guys. And I'm pretty sure y'all have already seen this, but why not, right? They did respond. Now, a good thing, they didn't just say, hell no, we going with Judge Clancy or whatever because, yeah, we don't like Holly. What they did say is, presiding Justice Mitchell, Justin, whatever, as follows. On the court's own motion, it is hereby ordered, appellate is directed to supplement the record with any exhibits, videos, or otherwise that were before the circuit court in her pretrial detention hearing. Now, on or before March the 25th, 2026, Appellate Johnson shall file these exhibits with the clerk of the circuit court. The clerk of the circuit court shall then immediately certify and transmit it to the clerk of the court, a supplement to the record of appeal, with any videos, exhibits made available in case center. Upon receipts by this court, the supplemental record will be treated as having been filed with leave of court. So they are asking for the video footage and evidence used in making this decision. They want to know what the judge saw, okay? They want to know the exhibits, videos, and anything else, not to determine whether or not she's innocent or guilty of first degree murder, but what was used to determine whether or not she can be released or not. Now, I do have those receipts. I'm not going to put them up, but I will go over them, okay? Would y'all like that? Would y'all like for me to go over the receipts? Now, it's not all the receipts, because majority of the receipts, if you go on the site, it says private, okay? Now, I don't know how we're going to get around that, but it says private, and to be honest with you, I believe it should stay private. However, y'all know some people got people in places, and they might be able to get to them. If they are, then I'm sure we'll get to them too. However, if we can't, we just can't. Okay, I believe that they should be for the appellate court only, but we'll just have to see. Nevertheless, right now they say private, but some of the receipts, I'm going to name them that they use. And I'm not going to go over them specifically, but I am going to name them, okay? So some of the receipts that was used during the motion in front of Judge Clancy for her release was, one, the TPO request, okay? Request for restraining order, and all of the threats that she said she endured by Romika, i.e., the text messages, the inboxes, the missed phone calls, how she blocked her here and blocked her there, how she was calling from her phone, her son Lilo's phone, how she got in her inbox, how she reached out to friends, because what happened was, Romika, once she found out that Carlos was the baby daddy, she was so angry about it that she went to Holly's social media. She looked up just some random ass man, right? That's in her friend list that she hadn't spoken to in a long time, right? And she reached out to him, but not only him, it was several others, and accused them of being Holly's baby daddy. So, can you imagine a female reaching out to your male friends saying, "You are the daddy of this baby"? Okay. So one of the receipts was uploaded where she reached out to one of her homeboys, somebody that don't even live in the same state, that she knew from a while back or whatever, but they are still friends on social media. She reached out to him and accused him of being the daddy of her child. And this is while she is still pregnant. Okay. To the point where Holly had to actually tell her, like, you're reaching out to people that you don't even know, because you can't get me off you can't get me out of your mind. You thinking about me when you go to sleep, when you wake up, like I am living in your head, right? To whereas Ramika respond like, I didn't even have to reach out to him today. He reached out to me, but she failed to say how she got in his inbox and said, "Can you call me?" Right? "Can you call me?" And then she proceeded to tell the man, trying to convince him that he is the daddy, to the point where the man actually sent Holly a email, a message. And this is what he said. He says, "I don't know what the fuck y'all got going on." This is what he said to Ramika. Ramika says, "Can you call me?" Right? And then he called her. Now, this is via Messenger. And then he responds and says, "I don't know what the fuck y'all got going on. I live in Houston. I ain't seen Holly in years. Never had sex with her. So please stop hitting my fucking line. I'm not the dad. I got 3 kids. Not ashamed of my kids, and I am very present. If that was my baby, I'll be at every visit, baby showers and all. So chill with the insecurities. Talk to your baby daddy, not me. I'm not that guy. Me and Holly are friends, nothing more. So stay off my line and inbox." Why did he have to do that? Why did he have to send Romika that message to her inbox? Because she was blowing him up. She was calling him. She was texting him, accusing him of being Holly's baby. Why? Because this woman did not want Carlos to be the daddy. Why? Because Carlos kept saying, "I don't know if it's my baby until I get a blood test." He would not claim the baby until he got a blood test. However, she's like, "But Holly is saying it's yours. Holly is saying it's yours." Carlos like, "I know that. I got it. I understand that. But I ain't saying it's mine until I get a blood test." But she wanted Carlos to admit that it was his. Carlos would not admit it was his for a good while, even though Carlos was showing up at the baby shower. Carlos was taking pregnancy photos. Carlos was, at different events that Holly was at, but he would not admit the baby was his for a good bit. Okay? Because he said he told me he had a homeboy that thought that he was the father of a child that was 4 years old, just to find out when they split, the child wasn't even his, the guy's, right? So he said he's the type of guy that he's not claiming no baby until he gets a blood test, right? So even though he was still chilling with Holly, he was not claiming the baby. However, Ramika and Holly was in communication at first. I don't know if you guys knew that, but they were in communication at first. And everything was kind of, a little cordial a little bit, right? So she was basically telling Ramika that, well, here's a picture of us, that I am pregnant, because, Ramika was trying to convince her that Carlos was not the dad. Now, Holly was trying to convince Ramika that Carlos is the dad. But can you imagine a girl calling you on the phone saying, "That ain't your baby daddy. Carlos ain't your baby daddy. Where your baby daddy at? Carlos is not your baby daddy." And she's saying, "He is my baby daddy. He is my baby daddy." So in the beginning, she was cordial. And then it became weird. And she blocked her. And when she blocked her, it became obsessive. It became obsessive before she blocked her. But That was another reason why she blocked her, because it got too much for Holly, okay? It got to the point where Holly could no longer deal with her rages, her obsession, her calling her back to back, because she wants to talk to her, okay? Because she was texting Carlos, and Carlos was ignoring the dog shit out of her. He was literally not answering her weird ass questions, right? She was asking him, "Are you the daddy? Are 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 you the daddy? Is this your baby? Is this your baby? Just tell me the truth. Is this your baby? Is this your baby? Are you messing with her? Just tell me the truth." And he was like, "We're not together, so he don't owe her that." Okay? And she even said in one of the text messages, "We're dating other people." Let me get to that one right quick. She was like, "We're dating, so why don't you just be honest?" But he didn't feel like he owed her that shit. You just my baby mama. I ain't got to tell you if I'm dating or not. I don't got to tell you where I'm laying my wood. All right. But Romika did not like that. Romika wanted him to tell her that he was involved with another woman, and Carlos didn't tell her because he felt like, why I got to tell her if I'm involved with someone else or not? So let me get to the part where she says, okay, let's read this one. This is Romika. She was trying to call him, and he says, "Can I call you later?" He said that 2 times. And then she says, "I'm fucking that truck up." Hold on, let me make it bigger. I'm effing that truck up since you want to be a bitch. I'm tired of you playing with my feelings. Watch. Delete the video now. Why can't you just tell the truth? Deleted the video now. Why can't you just tell the truth? I know you out with a bitch. And since we dating, so be it. What's the problem with you being honest? Meaning, since we're dating, she's dating someone else, he's dating someone else. She's like, well, since we're dating, so be it. What's the problem with you being honest? How you move, give yourself I think she mean how you moving, give yourself every single time. 7 years, you don't think I know when you on some BS? She said, "MF, I know you better than you know yourself. Just be honest this one time, like for real. I know already," shaking my head. So she said, "Amor, we can't see." Oh, okay, hold on, let me put it up. She literally wanted him to admit, hold on. Let me put this one up first. She wanted him to admit that he was dating Holly, and he would not admit it, and it pissed her off. Hold on. And from my knowledge, I don't even know if he was exclusively dating Holly. I think that they were just messing around, but that wasn't good enough for Romika. Romika wanted him to just say, "I'm dating Holly." And he wouldn't. He kept ignoring her, kept ignoring her, kept ignoring her. And it made her madder and madder and madder. Let me know if y'all can see this. If not, I have to blow it up. Can y'all see that? Let me know. But it says here, again, it says, hold on. Let me get back to it. Okay. She says, "I'm effing that truck up since you want to be with a B. Since you want to be with a B. I'm tired of you playing with my feelings. Watch." Now, what does she mean by that? From my understanding, okay, they were broken up, but they were talking about trying to work things out, okay? She says, "But who was she that he had to admit anything?" You're right, Real T. He didn't have to tell her shit. They dating other people. He did not have to tell her nothing. I agree. And he was ignoring the hell out of her. She's texting him one after the other, after the other, after the other. Like she was relentless with it or whatever. She wanted him to admit that he was dating someone and he wouldn't or whatever. And, from what I heard is she thought, or maybe they talked about or whatever, of them getting back together. She was supposed to go get some help or whatever on her disrespect and how she treated him and whatnot. She was supposed to be getting some help. They were supposed to be trying to get back together. and whatnot. However, they were dating other people, and he moved on. And so, and she even say that. Let me blow this up and let y'all see where she actually says, "You moved on, and I need to do the same." Hold on one second. I just really wish that she would have took her own damn advice. She knew it was time for her to move on. She just couldn't. She couldn't. Let me get to the part where she said, "You moved on. I need to do the same." Oh, it gets blurry when I ain't gonna be able to blow it up just simply because it gets blurry when I do that. Hmm. Okay. So it gets blurry. You really can't see it. But at the very bottom, you just got to blow your screen up. It says, "You moved on and I need to do the same." Okay. So she knew what she needed to do, but she just would not do it. She would not move on. I wish that she would have moved on. And, because I just feel like if a man is showing you that, he's not interested in you or whatnot, or even if he's playing you, like let's just say he's effing with her. Oh, this one might be a little bit better. Okay, let me put this one up. This one might be a little bit better. That he told her, "You moved on." I mean, she told him, "You moved on, and I need to do the same." Hold on. Let me put this one up. This is a different, better version. Thank you for sending me that. Child, women need to stop begging these men, honey. Y'all need to stop begging men to be with y'all. If a man don't want to be with you, just hell, there's a whole bunch of more out there. Shit, you can buy a man these days at the damn AB's. I mean, at the damn Adam and Eve store. So right here, you're so weird. This is why I never trust you. It's cool though. MF did that to you. She said it's cool though. MF did that to you. I bet you wouldn't like it. She can have you. You moved on. I need to do the same, is what she said. You see that? You moved on. I need to do the same. That's what she said in the next text. Let's go to the next text where she said, "You moved on and I need to do the same." Hold on. And then she says, "Why you keep lying to me?" And then she says, "F that baby." Hold on. Let me show y'all this. Let me just put this up. I don't know if y'all can see all this. Oh, yeah, you can. She says, "F that baby." You see what she says, "F that baby" at? Right here. Oh, this is the big as it gets, huh? She said, "Why you keep lying to me though? Hey, F you and that baby. My baby don't have a brother. He's a only child." Like, am I going to let's digress for a second, right? I always painted Romika as a bully, right? I always said she was on demon time on September the 8th. Do I believe she was on demon time on September the 8th? Yes, I do. But I will say something else today. Romika was not ready to let go when Carlos moved on to Holly. She was not ready to let go. She thought that they was on a break. She thought they was going to get back together, and she thought that was going to be her man, okay? She loved this dude. She loved Carlos. I think she was a little obsessed with him, if you ask me. But I think that she could not accept whether or not he told her the truth that he was with someone else or just ignoring her. Neither, either way, she was hurt. She was hurt. She was distraught. She wanted him so bad. And yeah, she absolutely did not want Holly to have his baby. She said, "I said that, and the picture that they painted that she was over him was a lie." Oh yeah, the over him thing. Well, the receipts definitely says that she wasn't over him. Okay, the receipts definitely says she wasn't over him because even when she says "f you" and that baby, she doesn't stop there. She continues on. And even when he was at my house, the text messages that I seen, she's relentless for keep on texting and texting and texting and texting and texting and texting and texting. She texts him all the time. And then this one, this is after she said F you and that baby, right? She says, "What you doing?" He don't respond. Shaking my head. "I know where you at, and it ain't home. Knew you was on some other shit. That's why I waited to see if you would play like them phones dead. You crazy. Be knowing what you really on and seeing what you gonna do," shaking my head. "I known you was gonna play the phones was dead role. Nah, motherfucker, you laid up and could have been real." So you wanna know why she says, "I know where you at and it ain't home"? Cause she done already pulled up over his house. You heard him say her pull-up game was what? Strong. Her pull-up game was strong. Okay? So with that being said, she had already pulled up over his house and she knew he wasn't home. But he wasn't answering the phone. And she's like, "I knew you was on some other shit. That's why I waited to see if you played like them phones was dead." Because, he may have said something like, gave her whatever reason why he didn't respond. Whatever reason, he could have just said, he could have been, some dudes would have been like, "None of your effing business," right? But he didn't. It seems to me that he had to lie to her to keep her calm. And I'm not giving him no excuse for lying, but I will say that some people do that. Some people will lie to you to spare your feelings. Am I saying it's right? No, I ain't saying it's right. But am I saying it's done? Yes, it is. Again, some people will lie to you to spare your feelings. Re-Rev said perhaps she simply wanted closure, transparency, and honesty. After all, you are in a lifetime relationship when you have a child with someone, in a sense. I get what you're saying. And I will say this, okay? I hear what you're saying. However, I'm a type of person that I feel like actions speak louder than words. So if you already moving funny and I'm accusing you of moving funny, is that not enough? So do you think words is closure? Because baby, the actions do it for me. The actions do it for me. If I see you ignoring me, I'm texting you back to back, 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 back to back. You ignoring me. I'm popping up at your house. You ain't there. You out. You lying. You doing this. You doing that. I mean, hello. Are we just gonna ignore the actions? We just gonna sit here and listen to what men tell us? And she was asking him, "Is that your B?" Let's get to that one where she said, "Is that your B?" She's asking, is Holly his bitch, right? He doesn't respond though. He doesn't respond. Hold on. Let's go back. Let's go to the one that she said, "Is that your B?" She did say, "I respect, honestly." Let's put this one up. This one right here. She said, "Yes, I'm tired of you lying. I want to know the truth." Shaking my head. "Why you keep lying? I respect honesty." So you want to play with me while she on the phone and call me a hoe? So apparently he must have called her a hoe while Holly was on the phone. And she got upset and said, "You snapped calling me a hoe while this bitch is on the phone. You for real? And when did I disrespect you and say anything foul except your lies? So you mad I told her you was around me? That's your bitch, huh? LOL." Now, from what I heard about this one right here, I don't know if this one, I don't know if the dates add up. This is October. So I don't know about these dates, but apparently she went back and told Holly some bullshit that they were together or they did something or whatever the case may be. And he got mad at her, and she says right here, "You snap calling me a hoe while this bitch on the phone. You for real? And when did I disrespect you and say anything foul except your lies? Your lies. So you mad I told her you was around me? That's your bitch, huh? LOL." And then she goes on to say, "LOL, you lie so much. They don't even know how you look, but stay away from me, op." And so she called him an op. So you would think, okay, she done, right? She done running up on him. She done uh pulling up to his house uninvited. She done blowing up his phone. You would think that she's done, but she's not. And it says right here, text messages from Ramika to Carlos. So this right here just shows how obsessed she was over this man. And it wasn't just to Holly. These receipts right here shows the obsession of Carlos just to Holly, right? And this is just for detention purposes. But when it comes to the trial, you're gonna see other receipts where this lady was obsessed with any woman, including her cousin, when it came to Carlos. She was obsessed with Carlos dealing with any woman, other women that was not Holly. Okay. She was very, very obsessive over him, you know. Um, let's she said often women are over the man and don't want him anymore, but at the same time don't want him with no one else, especially if she see him building with someone else. You're right about that. And let's go a little further. She knew, she was bragging even to Holly about, let's pull that one up. Was she bragging to, no, she was bragging to Holly how she was with another man, how she was receiving loving and flowers and shit like that. So she was dating someone else at the time that she was mad as hell about him and Holly having a baby. Let's get to that one right quick. Let's get to the one that she is like, let's put this one up first. Holly was basically saying, you reaching out to niggas that you don't know about me. I live in your head rent free. You wake up thinking about me. You go to sleep thinking about me. So Ramika responded, Holly Johnson, LOL. Again, Holly, that man called me today. I never called him, even text saying who he was. You slow, okay? And she says, let's get to the next one right quick. I'm going to get the whole part of the next one. She's trying to say that she didn't reach out to him, but she did. And they provided proof. So she says, Holly, you lie all the time, like you played with my son, calling him ugly and all. I can't wait to whoop your ass. Then she goes on to say, this is in her messenger inbox, okay? She says, Holly Johnson, like on everything. I fucking love that man called me today. I never not once reached out to him today. I actually had a beautiful morning to flowers and love. So yeah, I'm gonna let you stress that baby out on your own. You be worried about me and lying when I call him back. I said something, but again, she said I said something or some, but again, call him back. So she trying to say she called him back, that she didn't call him first. But mind you, in the let me show the text message where she asked him to call her. So that's why she's like, I didn't call him, he called me. But she jumped in his inbox and said, can you call me? Let me get to that one. And Holly was able to show all of this to her lawyer. So right here, the guy named, I want to say his name is Trail or something like that, or Travail. So this is Ramika Meek. She jumps in the inbox on social media and says, yo, can you call me? And she gives the dude her phone number. Again, this is in an email, a messenger on social media. Yo, can you call me? And then he respond, because he called. He respond and said, that's me, 713. And then Ramika said, you hung up. And then that's when he says, I don't know what the fuck y'all got going on, because at this point they were on the phone and she was trying to convince this man that the baby in Holly's stomach was his. But y'all, this was not the only guy that she called. She called several men in Holly's friend list, So listen, if you in some type of entanglement, I just say hide your friend list anyway. This internet crazy. Hide your friend list, y'all. Hide your friend list. If there's an option for you to hide your friend list, hide your friend list. Because people will reach out to your damn friends. You hear me? So she was reaching out to Holly male friends, more than one, accusing them of being Holly's baby daddy. So not only was she harassing Holly, she was harassing Holly friends. She said even if he told her the truth, she still wasn't gonna move on. They wasn't together. What else did she want? Exactly, they wasn't together, and he did not owe her that. Even though I know some of the ladies in here saying, well, she just wanted closure and this, that, and the other. Even if she wanted closure, I just got a question for you. Does he owe her that? Does he owe her closure if they are not together in a relationship? And he said they broke up after she called the police on him while he was on house arrest, trying to get him arrested. He said he was done with her at that point. So, what the fuck does he owe her? Excuse my language, but seriously, what does he owe her? What does he owe her? They broke up because she tried to get him arrested, locked up, and he was done with it. So closure? I don't know. So anyway, so Ramika tried to say that she didn't call him, but she failed to say, but I did jump in his inbox and told him to call me, and the guy did call. He called. And she said, you hung up. So after they talked and whatnot, he responded saying, I don't know what the fuck y'all got going on. I live in Houston and I ain't seen Holly in years. Never had sex with her because listen, how you gonna accuse someone that has never had sex with a woman of being the daddy? And then listen, let me show you where he said this man had to reach out to Holly and say, yo, she don't even believe me. Listen, he reached out to Holly and said, urgent, call me now. This is the dude, Tavel, talking about Ramika called his phone. He said he had to say to to Holly, urgent, call me now. This is a person that haven't seen Holly in years, right? She get a message in her inbox, said, call me now. Yo baby daddy, baby mama calling me. Thinking that we fucking around. She tweaking and won't stop calling me. Let her know I'm not your man. I'm trying to enjoy my day. She's blowing my line down. As I stated to her, I ain't saw you in years. She think I'm lying and think I am the dad. Shorty tweaking. Now, how embarrassing is this? Lord Father God. How embarrassing to have a man that you ain't seen in years hit you up in your inbox and tell you that your baby daddy, baby mama is calling him nonstop, trying to accuse him of being a daddy of a child, and he ain't never had the cooch. He never had the cooch. Who he supposed to be, Jesus? And then he said, she think I'm lying. She wouldn't even take, I'm not the daddy. We ain't messing with each other. I ain't never had sex with her. She wouldn't even take that as an answer. And who said that Carlos need to tell her the truth? She don't know how to take the truth. She can't handle the truth. Seriously. She can't handle the truth. This man telling her, I'm not the daddy. We ain't never had sex. Stop calling me. And she's still blowing up his phone. He said she blowing my phone down. She blowing my line down. I'm trying to enjoy my day. How embarrassing is that? How? There got to be some type of embarrassing for someone that's just a friend. Y'all know we get friends on social media sometime by just being in the airport together. Oh, what's your handle? What's your handle? Oh, my handle is let's talk about it with a more. I'll talk about it with a more. Okay, I'm sending you a friend request now. Okay, no problem. I'll accept it. She may not even have known the guy. Now, I'm not saying she didn't know him. Apparently, she knew him. But they may not be close-knit friends. Or the other guys that she reached out to, accusing them of being Holly's baby daddy. All because what? Because she didn't want Carlos to be the daddy. She did not want Carlos to be the daddy. She wanted it to be somebody else. So anyway, this is a receipt of this man saying, can you please, he's a shorty tweaking. She tweaking and won't stop. She tweaking and won't stop calling me. She has this impulsive, obsessive. And y'all look at how many times. Now, you remember that time we pulled up a call log and we was like, I think it was like 30 something times. Robert was calling Brianna back to back, back to back, back to back. And then all of a sudden he's like, oh, my phone malfunctioned and it was in my pocket and it just went crazy and it went off. And we was like, oh, yeah, all right, whatever, right? She's calling this woman at 1:35 in the morning, at 8:22 in the morning, 23, 24, 35, 45, 40. First of all, for what? Who you thinking about at 1:35 in the morning? Y'all tell me. Who are you thinking about at 1:35 in the morning? And then she went so far as to using her son's phone. Her son, Lil Lo's phone. Loso. She used her son's phone to try to confuse her. This is her not calling Carlos. This is her calling Holly. She was FaceTiming her, Instagram audio, leaving her messages at 3:56 in the morning, telling her how she was going to beat her ass. Yeah, this is going to be evidence in court. Just some of it. This is not all, you guys. This was used to get the restraining order. That's why this is being shown right now. This is definitely not all of it, okay? Again, this was shown just to get the restraining order. This is what she used to get the restraining order, okay? Now, she had an opportunity to go and say, this ain't true. I ain't hit her up at 3:56 in the morning and leave no message telling her I was going to whoop her ass. She was saying, I can't wait to whoop your ass. I can't wait to put hands on you. I can't wait to put hands on you, right? Loso. This is Lil Los. This is her son's phone that she's calling, FaceTiming, calling. She's calling from her son's phone, y'all. Romika Meeks Instagram audio at 3:40. Then she did another one at 3:56. Whoo! But wait a minute. Where the, I ain't even gonna ask them. But it was so many people on here saying, I don't believe it. Where's the receipts? Where's the receipts? Where's the receipts? Where's the receipts? I don't believe it. I don't believe Romika was sweating Holly. Who is Holly to sweat? They wouldn't believe it. They would not believe it. But these are the receipts. And there's also police reports where she had to call the popo on Romika for threats, you guys, threats. For threats. There is a police report, So again, Loso, her son phone, Romika Meeks, Instagram audio, Romika Meeks, Instagram audio, all early in the morning. Now, I don't know who Jazz is. I don't know if there was another person she was calling her from. I don't know, because I don't know why they would put that in here. But this is Holly's call log. And this ain't it. There is more, much, much more of missed call, block call. Let's look at where she actually tried to block the chick. Hold on. God dang it, Amora, why I can't? Give me a second. Did it just freeze up on me? I think it did. What the hell? Can y'all hear me? Did I go out? I don't know why this is doing this to me. I think it went out. Can y'all hear me? Hold on, let me put this down. Photos is stuck. Force quit. All right, let's bring it back up. Let me know if y'all can hear me. Can y'all hear me? Hello? Oh, she said we can hear you. Oh, okay. Let's go to where she tried to block the chick. She had to show the courts where she actually blocked Romika, right? Why does she have to block Romika? Because Romika was relentless. When she blocked her on the phone, that wasn't good enough. She had to eventually block Carlos's son phone. Not because she didn't want, if he wanted to get in contact with his daddy, he wouldn't be able to reach her phone. She didn't want to do that. But she had to because Romika was abusing it. Okay? But right here is where she had to show that she blocked Romika, but call me Meeks, on social media. I want to say this may have been Instagram or TikTok, one or the other. But she had to block her because the girl kept inboxing her, telling her how it's on site. When I see you, I'm gonna beat your ass. All because she was with Carlos. She was with Carlos. Okay? All because she was with Carlos. Right? She was so obsessed with this girl. She did not like it. She kept accusing her of breaking up their family. That's in text messages, but I don't think those messages have been uploaded or whatnot. But this is her. I think I showed y'all where she says she's getting flowers. Did I show y'all that? Hold on. She said, I actually had a beautiful morning to flowers and love. So she's saying that she's getting flowers and love by another man, but yet she's tripping over Holly. She tripping over Holly. So, nevertheless, you guys, there's much more coming as far as receipts. But as far as what was shown to move forward with a restraining order and things like that, and was used in court to determine her detention or not, that is what's being uploaded. Other video footage and whatnot will be uploaded as well. Okay. And yes, she was pregnant. This girl was harassed through her pregnancy. Now, T, I don't know if you knew this, but I believe you did. Holly tried to be cordial with her in the beginning. Literally talked to her from baby mama to baby mama. She tried to be cordial with Romika. It did not work. It escalated quickly. It became obsessive. It became weird to the point where she had to say, enough is enough. I'm not entertaining her no more. I'm not doing this with her no more. But she did, in fact, try to be cordial with her. She tried to talk. She tried to let her know, yes, I am pregnant by him. She didn't have to do that. She didn't have to do that, but she tried. She tried to say, listen, our sons are going to be brothers, so we have to get along. And she did try to get along with Romika. And she told Carlos, you got to fix this. We about to have brothers. You got to fix this. He tried. It was Romika that did not want it to be. She did not want it to be. They did have a conversation, and she said she was cool with him dating her or her dating him, but she said, but I'm going to still whoop your ass when I see you. So no matter, they got off that call after they kind of, was like, listen, we don't need to be doing this. You got a son, I got a son. They brothers, they share the same dad. And she said, I'm still gonna beat your ass when I see you. She just wanted to put hands on Holly. And Holly did not want that. Holly like, no, girl, are you crazy? She said, yeah. And she told her that she was still going to be exactly right here. She tried to be cordial with her. And Romika said, I'm still gonna beat your ass when I see you. So that was the first time that she had ever, September the 8th was the first time that she had ever saw Romika face to face. First time ever. And this is after Romika had threatened her. Now I'm gonna tell you this. Once Holly did block her, right, from the phone and social media, that is when she started reaching out to the family saying, I'm going to kill Kadasia Johnson. I'm going to kill your granddaughter, Kadasia Johnson. That was after she blocked her. Now, we do know of a story where another set of ladies, blocked another lady, right? This lady blocked another lady. I want to say the lady lived in Florida, blocked a lady that lived in, I want to say, New York. And the lady was so mad that she was blocked that she got on a damn plane and flew all the way to Florida, knocked on her door, said, I just want to talk. In the wee hours of the morning, I want to say 3 or 4, the girl let her in and she unalived her. And they asked the lady in court, why? And she said, because she blocked me. Because she blocked me. So because Romika wasn't no longer able to intimidate Holly, to bitch at Holly, to obsess over Holly or talk to Holly or cuss Holly out. Once Holly said enough is enough and she restricted access and not allowed Romika to entertain her anymore, once she did that, it pissed Romika off. So what did she do? She reached out to her family. Yep, Holly changed her number. She even changed her phone number. She started reaching out to her family, asking people for their home address. Now, mind you, Holly and Romika lived over an hour away from each other. Over an hour away. But she wanted her address. Why? Why you want somebody's address that live an hour away from you? Yeah. So, nevertheless, I think that, she was, this is my opinion right here. I believe that she was able to run women off from away from Carlos for a long time. And here comes Holly. She could not run Holly off, and it pissed her off. And I believe that she feels that Holly broke up their family. Well, she said it in a text. She feels that Holly broke up their family. She feels that they were supposed to be working on themselves and getting back together, even though they were dating other people. But the fact that he got Holly pregnant sent her up the roof. She wanted her son to be the only child. She didn't want Carlos to be the daddy of anybody else's kids. So, because Carlos was spending a lot of time with Holly, she couldn't track his move. Yep, he was spending a lot of time with Holly, and her pull-up game was strong over Carlos' house, but she couldn't pull up over Holly's house because she did not know where Holly lived. You know? So, nevertheless, y'all, I believe, let me ask you this, T. Do you believe that this will be overturned in appellate? Overturned for detention release? Do you believe this will be overturned for Holly to be detention relief? Because all them people was yelling, she ain't never coming home. She ain't never coming home. Never coming home. She ain't never coming home. Because they know so much. They know so much. She said, absolutely. Me too. I believe this is going to be overturned. I believe Ari did a hell of a job. And I don't know if you was in here, but did you, and I know you probably already read this, but do you see how Ari is discrediting discrediting witness 3 and 5? Lordy Jesus, she said absolutely. She got what she was looking for. I'm sorry. She was too unpredictable and Holly had to defend herself. Ooh, Rainy, honey. They're going to be mad at you for saying that, child. Leslie and all them going to have you on a billboard. Let me take your picture down before they come looking for you. No, I'm just kidding. I'm just kidding. But I do believe, who believes that this will be overturned in court? And if you don't believe it, say hell no in the chat. Say hell no if you don't believe that it's going to be overturned. She said yes with their own statement. Girl, yes. She is ripping them apart. Girl, did you see that Ari said that she never made it past the damn wall at the time of the shooting? She never made it to the damn, she never even made it to the smoothie shop. What the hell? How is it that witness 3 didn't make it past the smoothie shop? I mean, excuse me. She never even made it to the smoothie shop. Like, good Lord, girl. You ain't even make it to the smoothie shop? All this time, I'm thinking that at least you saw some shit from the smoothie shop. If Holly didn't do it, we would be saying justice for Holly. That girl was mad as hell. He had another baby. Girl, she said, yes, honey, that is T. I said, she didn't see shit. I mean that, baby. That's what the defense attorney is saying. That's exactly what the defense attorney is saying, that she could not have seen what she claimed she saw, baby. You hear me? Now, we always knew that, but I thought somehow when it came out that the shark's camera was so many minutes behind that all of that footage where they saw her ducking behind the building, this, that, and the other, I thought it was null and void. Damn, I'm about to get all tongue tied myself. I thought it was null and void. But baby, when I saw that it said that the pod camera seen her, she was spotted on the pod camera. The pod girl. The pod camera. So when she was spotted on the pod camera, walking in the opposite direction and ducking and dodging behind buildings and shit, 52 seconds from the time she dialed 911 saying that she saw him hitting her door in the back, 52 seconds later, that girl was spotted going in a whole nother damn direction. Past the damn, the greenway, the green line. Past the green line. How the hell she see? She got eyes in the back of her head. Girl, when I tell you, baby, and I'm going to tell you something. A lot of people ain't going to like this. They ain't going to like that Ari is tearing down Witness 3 and 5 as being non-credible. A lot of people are not going to like this. Majority of the people are not going to like this. Why? Because they lived and swore by Witness number 3. They have repeated every word. I'm talking about every word that Witness number 3 have said. And she grabbed that shit out her ass or esophagus 1. Wherever she grabbed it from, it damn sure didn't come out of her memory. Okay? She was huddled with everyone after the incident. They were all swapping info and she added in what she heard. Baby, she didn't see what she said she saw though. She didn't see what she said she saw. So I believe that Miss Ari gonna dog walk her. And I said that in the beginning. I said Ari is going to destroy her because that statement that she said on the YouTube channel was inconsistent, right? She had so many inconsistencies in there. But how you gonna listen? How she gonna say the shots was rapidly, or what did she say? Successive. I think that's the word she used. And now all of a sudden it was a pause. Now, I'm gonna say this. I ain't trying to defame the Chicago detectives, but what I will say is I think that word pause may have been spoon fed. Okay? Why do I say that? Because another witness said pause too. Who going to the police saying, oh, and there was pause between each shot? Who would even think to say anything like that? Oh yeah, and there was a pause between each shot. Right? But she didn't say that at the time of the body cam footage, right? So I believe it was spoon fed. Like, you know, was it back to back, boom, 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 boom? Or was it shot? Let's think about it. Shot. Let me think about it. Shot. Let me think about it. Right? So I do believe that a couple of things were spoon fed. And I think one, the pause behind each shot, I think that was spoon fed. Now, not accusing them of anything because I don't know them like that. I don't know the Chicago police like that. But it sounds, now we're talking about a 21-year-old. We're talking about a 21-year-old that, well, I ain't even gonna say. We're talking about a 21-year-old, y'all. A 21-year-old that's with her baby, with a stroller, with headphones on her ear, right? Now, you already know if you pushing a stroller. First of all, we can't do a whole lot at one time, right? If you concentrating on walking, you concentrating on pushing your baby, you concentrating on a busy road, it's early in the morning, you got on headphones, you ain't hearing no whole conversation of nobody around you. And then, did you see the part where Ari said, witness number 3 said the reason why she heard things on the bus is because the bus window was open? Just for them to find out that the windows were not open? Why did she even add that lie? Why was that necessary to say? Because she know you can't hear shit on that damn bus. So that's why she threw in there that the windows were open. But they proved that the windows were not open. Girl, I wonder, did witness number 3 think that Ari was gonna do her damn homework? Did she just think that, oh, I could just make this statement and y'all just believe it and ain't nobody gonna verify? Ain't nobody gonna come behind me and say nothing. You know what I mean? Ain't nobody gonna say anything. I'm just gonna say whatever the hell. Let me just say some shit and move on. I don't think that she really thought that this will be investigated and looked more into. Yeah, the state bought your bullshit, but not the defense. She didn't know she was on candid camera. Girl! Oh, she didn't know that he had that body cam, is what you saying. So she was saying whatever, and she didn't know at that time she was, ooh, girl, you said she did not know, neither one of them did. Nobody there that gave the police a statement, not even Carlos, knew that they were being recorded. They didn't know. She didn't know she was being recorded. So the next day, she goes in and completely changes her story. Oh, yeah, even on the bus. Exactly. She didn't know on the bus that they was only going to catch her looking out the window for a short period of time and then turning back to the front and tending to her own child. To be honest with you, I'm not saying she's wrong for being a witness and want to do the right thing. But I'm just going to be honest with you. If my baby is with me, I ain't studying being no witness to nobody else's case that ain't got shit to do with me. I'm just keeping it a buck. Y'all let me know in the comments, you with your child. I understand you just heard a gunshot or whatever. But are you about to be a witness? I'm just asking. I'm just asking because, girl, I ain't got time. I'm about to get where I'm going. I'm sure she has somewhere to go. I'm not, even if I did see some shit, I'm not about to. I got a child to take care of. I'm with my child. It's early in the morning. I got shit to do. I'm not about to go down there no chaotic, bloody, unaliving. I'm not about to sit out there with a whole bunch. I don't like being around people like that anyway. A whole bunch of people, bunch of strangers with diseases flying all over the place or whatever. People got colds or whatnot. I'm not about to be amongst them like that anyway. She said, who page did she do an interview on? I want to hear it. Rainy, you never heard the interview? I have played that interview on my page. I think I even have a breakdown of it on my page. But the interview that she gave on the YouTube channel, baby, can you say embellishment? She embellished the hell out of her story to the 15th power. Let's get to the part where witness 3 said that the window right here, y'all. Let me highlight this where Ari noted, okay, that she said she heard what she heard on the bus, right? Because the window was down, and Ari and her investigators proved that the window was not down. How many other lies do y'all think that witness number 3 have told? Listen, once, let me get my ruler. Let me get my arrow, my ruler. Right here, y'all. Once off the bus, witness 3 walked eastbound, blah, blah, blah. Look, let's go on. Witness 3, views of the shooting, okay, was obstructed. Hold on, let's get to the part what she said about the window. Hold on. Oh, it's up here. My bad. Ooh. Right here, y'all. Look. While traveling eastbound on the bus, she observed the incident between all 3 parties for only 10 seconds and did not call 911 until after she exited the bus. She claimed to hear Mrs. Johnson threaten the deceased while traveling on the bus. Since the bus's window was open, however, Not only was the window closed, but witness 3 also wore thick wireless headphones over her head. So let me explain something to y'all. And I'm gonna let y'all hear it. Let me let y'all hear it. I learned this and I want y'all to learn it with me, okay? I want y'all to hear what I learned. Give me a second. Give me a second. Give me a second. Okay. I'm asking ChatGPT something and I want y'all to hear. So I asked, can a defense attorney call a witness a liar or do they have to frame it a different way? Okay. Now, the reason why I want y'all to hear this is because I learned this myself through just my research that is not good for a defense attorney to call a witness a liar. They're looked at as being defensive, abrasive, and some other shit. Okay. So I learned that and I want y'all to hear why this is the case. Okay. Listen up.
Great question. This is actually a very important courtroom nuance, especially for how juries perceive credibility. Short answer: a defense attorney generally should not directly call a witness a liar in court. They are expected to frame it differently, even if that's exactly what they're implying. Why they avoid saying liar. 1. Improper opinion on credibility. Lawyers are not supposed to give personal opinions about whether a witness is telling the truth. Argue credibility in a personal, emotional, or inflammatory way, saying, open quote, you're lying, close quote, be objected to as argumentative, improper, invading the jury's role. Determining truthfulness is the jury's job, not the lawyer's. What they do instead, strategic framing. A good defense attorney will expose the lie without saying liar. Cross examination techniques. Isn't it true that earlier you said? So your testimony today is different from what you told police? You want this jury to believe that? Highlighting contradictions, prior inconsistent statements, timeline conflicts, physical impossibilities, suggesting bias or motive. You have a relationship with the victim, correct? You were angry that day, weren't you? What they can say, especially in closing arguments. In closing arguments, attorneys get more freedom. They still shouldn't say, open quote, I think she's lying, close quote, but they can argue. The evidence shows this testimony is not credible. That story doesn't make sense. You cannot rely on what that witness said. That's basically calling them a liar without saying the word. What happens if they do say liar? Opposing counsel can object immediately. Judge may sustain the objection, instruct the jury to disregard it, warn the attorney.
Okay. So, with that being said, you're not going to pretty much see Attorney Ari calling witness 3 and witness 5 a liar, even though it is what it is, right? You may not see her calling them a liar, but what you will see is they are non-credible. Now, we as bloggers can say whatever the hell we want to say, right? You know, that's our opinion. However, right, Attorney Ari, you're not going to pretty much see her say that witness 3 and witness 5 lied. She's going to frame it as they are non-credible witnesses. So again, so let's go back to what she said. She said she claimed to hear Mrs. Johnson threaten the deceased while traveling on the bus since the bus window was open. However, not only was the window closed, witness 3 also wore thick wireless headphones over her head. She had to remove those headphones when speaking to the police on the scene, suggesting impaired hearing with the headphones. So she's basically saying she lied about saying, I heard what they were saying on the bus because the windows was wide open. And Attorney Ari then sent her investigators to find out that the bus they were on, either the windows don't open or they were not open that day. Because why? Girl, there's video footage camera on the bus. Now, let me ask y'all a question. Because, this ain't something that I would have known, but I don't ride the CTA. How many people in here, by the show of hands, did not know that these buses record your every move? Now, I'm going to be one to raise my hand because, one, I don't ride these buses. And no, I wouldn't think a bus is video recording me. Now it make me feel a little eerie while I'm on the bus. I got to make sure I don't pick my nose or do nothing crazy. I guess everywhere you go, you being recorded. You gotta just act like you on reality TV wherever you are, except for the comfort of your own home, right? But how many of you guys did not know that you were recorded on a bus? She said all buses have cameras on them. She said the cameras are visible. Okay. So I wouldn't have thought to even look for a damn camera. She said the cameras are visible. Tammy said she wouldn't have known. So Tammy, you wouldn't have known. I wouldn't have known either. In Chicago, is signs that say it. Well, maybe she didn't think that they were going to pull the camera footage. She said there's cameras everywhere, even on the train and the plane. Listen, she said, I haven't rode one in years. So either this young lady, I'm not gonna say she didn't know about the cameras. Maybe she thought that they wasn't going to do that much investigation. Because to be honest with you, what would make Ari pull video cameras of the witness sitting on the bus? What would make Ari do that? Ari wanted to track her whereabouts. I love the way she thinks, because I'm telling you, I wouldn't even thought to track this girl whereabouts. I wouldn't even thought to track, where the hell were you at the time Romika bust a U-turn? I wouldn't even thought to even do that. I wouldn't have. However, Ari did. Ari thought about it. Let's go track this girl down. And Ari said she was in Chinatown when Romika bust a Yui. All right. So nevertheless, not a Yui, I'm sorry. I think she said they was in Chinatown when they came out the house or something like that. I have to go back and look at it. But nevertheless, the defense is doing their homework. They're not just letting the state push a narrative. They're going to make the state work, okay? So I do believe that this is a good appeal write-up. I know that people that are not in support of Holly will think quite differently. I have not heard any of things that they said. They may have read this whole 18-page document completely different. Raise your hand if you've listened to them read this document and it was explained quite differently. And they explain it like this is some bullshit and not strong enough to get Holly out. Let me know in the comments if you've heard them read this document and they made it seem like it was weak, water, and it wasn't going to work to release Holly. Because I actually find it to be very strong. I find it to be very detailed for what it needs to be. Now, of course, this doesn't win no case. This does not win a case, and we know that. There's way more things that's needed to win a case. But I think that this is strong enough to get her released from detention. She said it was so much that did happen that she didn't mention that would make Ari check it out. Yeah. I think that there is way more information that's going to be released. Way more. People are always trying to sue, so cameras are necessary. Oh, cameras is very much necessary. That's what I like the fact that hell, and I like the fact that a lot of things are caught on camera. It kind of made me feel a little safer out there in this world. If somebody do something to me, they gonna be able to track who the hell did it down. That's how a lot of these murks are being solved. Cause people don't think they on camera some damn well. Like the double murder out of Ohio. He thought he was the smartest thing ever since he had 15 years of schooling to be a damn surgeon, right? But he didn't think people had doorbell cameras that saw him walking from the house all the way to his car. Joker, you know? A lot of people don't believe it, even in the newer cars, the newer OnStar system, or whatever you call that shit. Oh, they got cameras too? God damn. She said, yes, like that Rat Downer and the mayor or Dalton. They sound crazy reading this. I have no idea who those people are. The Rat Downer, I don't know who those people are. Real team. Are you just gave them some nicknames? She said people were getting on the bus fighting the bus driver, so the cameras were put on the bus to protect the bus driver. Oh. Witness number 3 is all they have, and she was behind the damn building. They probably gonna drop the case right before jury selection. Girl, listen. When I'm like, wait a minute, because I had heard that, and then it kind of like fell apart when the whole, oh, the timing was off and this and that. I was like, damn, right? But now to see Ari push this up to the appellate court saying that this footage, she didn't even mention Shark's footage in here, and I like that. She didn't mention nothing about Shark's footage. She mentioned CTA footage, the school footage, and the pod cameras. I love that. I love that. So she don't even have to explain. And I think that was probably one of the reasons why the judge kept detention, because that was a big boo-boo. You know what I'm saying? That was a big boo-boo that she presented some information where the cameras did not, the timing did not align. So I believe that that was one of the things that made the judge say, nah, your timing is off. So where you saying she was, yeah, no, that ain't it, because you saying it came from Shark's camera. But now she said, fuck, excuse my language. She said, forget Shark's camera, honey. We going off the pod, baby. Forget Shark's camera. We going off of the pod camera. All right? You know? She said, my old assistant's pastor's son took the life of a lady on the train, and they showed every step he took before and after. Yes, you know what? I seen another, it was on a bus in Charlotte, North Carolina. It was kind of a guy, he was kind of a little off a little bit. The girl was minding her own business, and I think she was a Middle Eastern young lady or whatever. She was minding her own business, not thinking about this guy at all. I think this was in Charlotte. Y'all tell me if I'm wrong. But this guy got on the bus. He was sitting behind her. And I don't know if he said he got voices going through his head, but he literally took her life and just started stabbing this innocent lady that didn't even look in this man's direction. She didn't even know what was coming. She didn't even know what was coming. And her life was taken right there on the bus. And then the guy, when the door opened, he walked out the damn door. Like he ain't just unalive a woman, a female. He said, I think if I'm not mistaken, I think he said that he heard voices telling him to do it. I used to think that people said that they heard voices was, not being honest, right? I'm like, they ain't heard no voices. They just saying that trying to play crazy. But no, I actually think these people be, she said that's the one, he had mental issues since a teenager and had just left the hospital asking for help and they turned him away. Oh, that's a pastor's son? That was a pastor's son? Oh my God. Dang. Well, anyway, thank God for cameras. Thank God for cameras, okay? Now, unfortunately, with this situation, the incident itself was not caught on camera. Now, I believe, this is my belief, that if it was caught on camera, Holly wouldn't even have to go through trial. I believe that she would be found innocent, due to self-defense, right? However, because it was not caught on camera, and then you had witnesses that come forth and gave a whole damn weird, crazy story about this and that, I believe that that's why the case moved forward. And then, of course, the public. But, I have to say this because I want to believe that attorneys, whether you are a prosecutor or a defense attorney, that you got a little intelligence to you. You're kind of smart. So I believe the state knows witness three statement have holes in it. But I also believe that they are banking on Ari being an inexperienced trial attorney when dealing with first degree. Okay. She has not had many litigations, when dealing with first degree. She win majority of her cases outside of the courtroom. So litigations is when you go and you argue your case. Ari doesn't have a lot of litigations, right? So I believe that the prosecutor knows that witness three and probably witness four statements, you know, are weak. However, I think that they were looking at Ari is because I looked it up one day and it said this case is beatable with a good defense team, and I think the state looked at it like, oh shit, we got this in the bag because Ari ain't good. They all, let's just be real, they be thinking black people don't know what they doing anyway, right? They be thinking, oh shit, I'm gonna beat this because they ain't gonna get down and work real hard for it or whatever. But I just don't believe that in Ari's case. I believe because Ari needs this case. This is a make or break for Ari. Who believes this? This is her first degree murder trial taken to court. She's had attempted murder. She's had second degree murder. She's had sexually assault. But this is Ari's first degree murder. And let me correct myself, where she is lead attorney, because she has been on cases where she was helping with the case. But this is her baby right here. She is the lead attorney on this case. So the fact that she is the lead, this is a make or break for her career. So, because of this, and y'all know how us black women are, she's giving it her all. Because if Ari wins this case, this opens many doors and opportunities for her. They're going to be like, oh, you beat this shit? Oh, I'm going to Ari. I'm going to attorney Ari. Let me go spend my money on Ari. Now, if she lose, not so much. They're going to be like, damn, her first murder trial, first degree, and she lost. Again, Ari is good with finding loopholes in the system, dealing with the paperwork, dealing with appellate court, dealing with the, pressure in the state to do their job in a timely manner, right? However, this one right here, if this goes to trial, this will be Ari's first degree murder trial case. Her first time litigating in a first degree murder trial as a lead attorney. So this is big for her. She said they just so happened to be in the area where the cameras were behind it. Oh yeah. So this is big for her. She said Ari is the defense team. Yeah. So this is big for her. But I will say this. Do I want to see her win? Of course I do, but not just for Ari's sake, for Holly's sake, of course, but also for Ari's sake, but also for the sake of self-defense. I do. I want to see this case won because, and the reason why I want to see it won is because if it is lost, what's the message here? The message is you could be getting stalked and harassed by a person. You can go to court and ask for them to intervene. You can block them. You can, call the police and tell them that you're being threatened, right? You could do everything, and this person can still pull up on you after threatening to beat your ass and KI you and even threatening your son, right? And they can pull up on you and want to fight you. But if you defend yourself with your approved carry, certified carry, then you can go to prison. So I don't want that message sent. I want the message sent that if you stalk, harass, and threaten someone, all because you don't like them and you pull up on them and want to get your one, that you got to deal with the consequences. And the consequences might not be pretty, but the person still walks if they defend themselves. So I want Holly to walk because I think it's going to send a nasty message. In my opinion, it's going to send a nasty message if she has to spend time in jail. I think Holly did what was necessary. I think that she tried to avoid this. I do. That's my opinion. She tried to avoid this. She didn't ask that girl to pull up. She didn't ask her to get back out her car. Witness 3 was nowhere near to see her threatening and provoking Romika to get back out her car. No, no, no. No, no. I don't believe that. I believe Romika got back out of her car because the job that she came to do was undone. It was undone. She came, when she bust that Yui, she said, oh, I'm about to beat this bitch ass. That's my opinion. That's my opinion. I'm about to beat this bitch ass, right? So she said, I'm about to beat this bitch ass. She got out of that car, and that was her intentions. So when she got back in the car, she got back out because the job wasn't done. That's how I feel. Do I feel that Holly provoked her? Hell no. No, I do not. I do not. Okay? So she said, in my state, if you pull up on someone and get killed, the DA said he won't be prosecuting the shooter. What state you live in, girl? What state do you live in that say that if you pull up on someone and get killed, the DA said he will not be prosecuting the shooter? Woo, child, but don't pull up on nobody. And you know what? I'm going to go over a case that was sent to me, not tonight, y'all, but who knows, maybe tomorrow. I'm going to go over this case where it was 2 rivalry gangs. They were gang members. They were rivalry for a long time, going back and forth with each other, right? And one pulled up to the guy's house and he was filming. All he did was knocked on the door. That guy came out there with that weapon and baby, he sent him to Kingdom Come. Kingdom Come. Now you would automatically think, matter of fact, you know what? I'm going to show it right now. Do y'all mind, since y'all with me, do y'all mind a couple of more minutes with your girl? It's not long. Do y'all mind? Let me know if y'all mind. Because if you don't mind, I want to show you something. Do y'all mind? Let me know. Let me know in the comments. Or are y'all asleep? She said, what was the case in California? No, 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 no. Oh, you talking about something different. I know what you're talking about. He was a baseball player. No. Mm-mm. Oh, y'all talking to each other. Because the one I'm talking about are rappers. These are not a baseball player, what I'm about to show y'all. But I'm going to show you something. Before I show you this video, let me read what it says, okay? This right here says, in St. Louis, Missouri. Now, I don't know why. You know, I got some supporters in St. Louis. I don't know why St. Louis keeps staying in the news. St. Louis, Missouri, a 19-year-old rapper was pum-pum and KI'd after walking up to his rival's apartment and knocking on the door in broad daylight with the entire incident captured on surveillance. The shooting happened February the 28th of 2026 in Peabody Darts Web neighborhood. Video shows WAP blocked J4, dressed in all black, approaching the unit while holding his phone. He appeared unarmed as he knocked several times. Seconds later, gunfire erupted from inside the residence. The rapper collapsed on the porch after being hit multiple times. The person believed to be responsible has been identified as an online rival slap person, though authorities have not officially confirmed that identification. The footage showed the full sequence clearly in daylight and has since spread rapidly online, fueling reactions across the St. Louis rap scene. Officers responded to the 1200 block of South 13th Street, directly across the Peabody Elementary School. Directly across from the school. It says, and found the victim suffering multiple gunshots. He was transported to a hospital where he was pronounced dead. Investigators say the killing may be tied to ongoing rivalries within the local drill scene. WAP Block J4 maintained close ties with artists Mo P and 1448 Crew, which has clashed with affiliates from the French Town set. I guess that's some gangster stuff. One person is currently in custody for questioning, while homicide detectives continues to pursue leads. No formal charges have been announced. The investigation remains open. So I'm going to show you this video, right? And then I'm going to ask you a question. Okay? Let's watch the video.
50 in my tutu, bro, shit got the Vic. These niggas claiming beef, it ain't no beef if you ain't hit the jets. Hit through the grape, ain't shit.
I'm going. I'm going to let you see it again without the music. He knocked on the door. He got his phone because he on live. And you see what happened. Now, I have a question for y'all. What is this? First degree, second degree, manslaughter, or innocent? Let me know. This was in St. Louis, Missouri. While y'all answer that, I'm going to pull up the news clip. While y'all answer that. What is it? First degree, second degree, manslaughter, or innocent? Y'all let me know in the comments while I pull up the other one. Let me see what y'all said. Okay, Cassie said first degree. Is that the only person? First degree. All right. How many other people think it is first degree? Do y'all need to see it again? I think a lot of people are asleep. I think a lot of people are asleep. I know it's late, y'all. I know it's late. I need to let y'all go to sleep because only 2 people has answered. Anybody else want to take a shot at it? First degree, second degree. We got 200 people in here. I know all 200 people are not asleep, y'all. She said, yeah, play it again. Okay, let me play it again. Let's play it again. All right. Let's play it again. Give me a second. He walks up on the porch. He knocks on the door. He got his phone because he live. You know, he got to record everything. As soon as he opened the door, he starts firing. He shoots him down. The dude takes off running and dropped dead about a block or so away. But as you can see, let me take this. Can I take the wording down? I don't know if I can. No, I can't take the words down. But do y'all see how he knocked on the door? He never entered the home. So I see some people said, I can't decide. First degree, play it again. First degree, Castle Doctrine. I just woke up, manslaughter. He came to his home. So, okay. So a lot of y'all say y'all think that this guy with the gun Should have been charged with first degree, right? All right, well, listen up. Listen up. This is people need to be careful, okay? So, no charges filed in fatal shooting of St. Louis rapper. Honey, no charges filed, meaning this guy got off totally free. Why? Because they were rivalries, right? You don't just pop up at somebody's damn house. What was your plans? They had already been threatening each other with death, okay? Listen
There
up.
had to be, based upon, I'm sure, witness testimony or statements, something more to this.
But first on Fox, a deadly shooting caught on camera. But the man police had in custody is let go with no charges. This all comes just days after a 19-year-old was killed in the Peabody neighborhood of St. Louis. The whole incident was recorded, leaving some to wonder why no charges have been filed. Fox News' Chad Mira reports, all new at 10.
The shooting out here on South 13th Street was all caught very clearly on camera. However, the circuit attorney declined to press charges, raising new questions about what led up to that shooting. A shocking video online shows the moment 19-year-old St. Louis rapper J4 was gunned down in a rival's front yard on Saturday.
There had to be, based upon, I'm sure, witness testimony or statements, something more to this.
We can't show you the video here, but it shows almost immediately after J4 knocked on a door, a person came out with a gun and started shooting. A suspect was detained that weekend, but Fox 2 has confirmed that person has been released with no charges. Some people commenting online say this was self-defense. We showed the video to defense attorney Joel Schwartz for a legal perspective.
In a vacuum, it does not appear to be reasonable self-defense. However, that's without knowing any of the factors surrounding the incident that occurred.
The day of the shooting, our crews noticed bullet holes in the alleged shooter's windows. Schwartz says Missouri has some of the strongest self-defense laws in the country, and even prior threats could be relevant. We asked Circuit Attorney Gabe Gore's office why there haven't been charges despite the video evidence. They sent a statement saying, quote, "Our attorneys carefully review the facts and evidence in each case and make charging decisions based on the law and the facts."
It hurt because I was his mentee and I wish I was there for him.
Tavon Brooks met J4 a little over a year ago. He says the feud between rappers shows kids need more programs and activities.
Not once a week, daily. Because in the case of J4, if he had it daily, he probably would have been focused on his passion.
But for now, he's reserving judgment on the circuit attorney's decision and is instead focused on honoring J4.
He was a happy child, very compassionate, very involved, very loved music. He loved his family.
Both the circuit attorney's office and SLMPD are asking for more tips in this investigation. We have their contact information on fox2now.com. Reporting in Midtown, Chad Mira, Fox 2 News.
So, their DA in St. Louis, Missouri, failed to prosecute, right? Said, nah, we ain't doing this based on prior threats, based on this guy's house had just got shot up, days prior, based on they had been going back and forth with each other for a while. So the prosecutor in Missouri says, nah, J4 had no business walking up to that man's house, okay? So with that being said, he knocked on the door and lost his life. Now, I don't know if he had a weapon on him or not. I don't know if he had a weapon on him and it fell off of him as he was running because he ran away. I don't know. But what I know is the guy that came out of his door and pew-pewing him is a free man. Self-defense. No charges filed. Now, of course, some people mad because they want to say J4 was really, really sweet and kind and all of these nice things after the fact. But that 19-year-old lost his life when he approached his rivalry's house after multiple threats that he had already given him. And now he was on live. I'm sure he probably was like, oh, I'm going to go bitch slap this dude or whatever, right? I don't know. But yeah, he came to his house. So nevertheless, that's just what happened. She said gang members in possession of firearms will never do. So Missouri failed to prosecute. So different states do different things. But I believe had witness number 3 and witness number 5 had not come forth with this embellished as witness statement saying, I seen this and I seen that and I seen this, I believe that Holly would have gotten off as well. But because there are witnesses there that said Holly was the aggressor, Holly provoked Romika, and so forth and so on, I believe that's why it moved forward. That's my opinion. That's my opinion. She says, I'm not surprised. This is typical with black on black crime. Hey, you know. She said, I'm not sure about this one. Well, honey, if you live in Missouri, not only do you need to keep your hands to yourself, but don't run up on nobody. And the reason why I showed y'all that is because the young lady that said her state said that they will not prosecute if you run up on someone. If you pop out, you pop over somebody's house, you pop up to their location, and you want to be on one, it looks like the DA is like, okay, well, you asked for it. And to be honest with you, I know it sounds cruel because there's a lot of people that love Romika. But how can we say Romika didn't ask for this? What did Romika think? You don't tell someone how to fight back. Now, I honestly, do I believe that she thought that she was going to get KI'd? No. I think Romika thought that she was going to beat Holly ass and go wherever she was going, to work, school, whatever. But she got out with bad intentions. She hopped out with bad intentions, and it just cost her life, So nevertheless, y'all, I know it's late. We've been on here for 3 hours and 47 minutes. Let me ask y'all something. Are y'all loving these late night lives or no? This is on Saturday. I will be going late like this so I can sleep in on Sunday. It's 2:47. I'm going to take me a bubble bath and go to bed, and I'm going to sleep in tomorrow. But let me know if y'all liking these late night lives, or are y'all over there asleep and just got your TV running and got me on there giving me the watch hours, which I appreciate. Which I appreciate. She said, yes, I love sleepovers. You love the sleepover? Who else is loving these late night lives? Let me know. She said, yes, but this live was so good. I wish more people saw it. Oh, thank you, lovely Jim. I appreciate that. I really do. She thought Holly was a punk and she got punked. I'm going to tell you something. I don't think those that don't like Holly will watch. I think they were told not to watch my videos or whatever because they don't like my stance. And that's fine if they don't watch the videos. It's really for those, to be honest with you. I'm not doing it for them to watch it, though. I'm doing it for the people that, think more like me, right? Think more like me and see things, through all lenses and not just one emotional lens, okay? And that's not a lot of us. Unfortunately, it's not a lot of people out here that think self-defense was justified in Holly's case. They think quite the difference, the opposite. They think that Romika should still be here today. I actually think Romika should still be here today too, if she would have continued going and stopped being so obsessed with Carlos. If anything, I feel like Romika should have just realized that her and Carlos was over or whatever at that moment anyway, and went on by her life. She was a beautiful woman. She could have went on. I'm sure she could have got whatever man, her heart's desired or whatever, She said, me, I had to get me a popsicle. You had to get a popsicle, girl. So I came in late, so I'm going to go back to the beginning. Thank you, Super Leo. I'm going to replay what I missed. Thank you, Dupu. Yes, I love the sleepovers as well. This was a great live and more. Thank you, Gloria. Thank y'all so very much. So I'm going to be doing this on Saturday nights, spending time with the family during the day. And then at night, once they go to sleep, that's when I'm going to be going live. And so I'm glad I had this 18-page document to break down. I was going to break some other stuff down. Like y'all know Stoney went live today with the BS saying that that Cora producing, what did she say? Mass content. Cora producing mass content is against the law. Like, girl, are you crazy? I'm beginning to wonder, is Stoney all right, y'all, or do she need some medicine? So I'll be going over her live tomorrow where she actually states that And I have to work tomorrow simply because I was off for like 2.5 days. So I'm a little behind. And yes, I'm trying to make up a little bit. She said, no such thing as black on black crime. You know, I hear what you're saying, TJ. There's no such thing as black on black crime. I think they say that when a black person kill another black person. But you're right when you say there's no such thing as black on black crime, right? Simply because you don't hear white on white crime or Hispanic on Hispanic crime. However, the crimes that you're in the most, your community, will happen amongst your community, meaning that the black community will most likely have black people killing black. The white community will have white people killing white. The Hispanic community will have Hispanics killing Hispanics, and the Asian community will have Asians killing Asians. But you don't hear them referred to other ethnic groups as Asian on Asian crime, right? So they do put that black on black crime, which is a racial stigma, right, that they put on us years ago. So you're right, there is no such thing because, again, people commit crime in the community in which they are in the most, okay? So if you did a poll and see in the white community who does the most crimes, well, white people on each other. In the Asian community, Asian people on each other. Hispanic people on each other. So yeah, anyway. She said, why are you living under a rock? What rock are you living under? Who, me? What rock am I living under? What do you mean? What does that mean? She said, yeah, but these messages you showed was tea. They wouldn't be scattered if that was posted earlier. They wouldn't be scattered. They would have been scattered if that was posted earlier. What are you saying, lovely? Well, lovely Jim. Let me know. Let me know. And Reb, what do you mean? What rock am I living under, Reb? What are you talking about? I'm not sure what she's talking about. So anyway, she said, "Yeah, I love sleepovers." Oh. So anyway, y'all. So again, thanks for pulling up. So we should be. Oh, let me see when it's due in. Hold on. Let me see when the results are due in, so that we would know what to expect. Hold on one second. They are giving her until March the 25th. So she has until today, Sunday the 22nd. So she has until Wednesday to upload all the evidence that she wants to present to the appellate court. So March the 25th is when they are asking for all evidence that just not evidence for the case, you guys, evidence used in releasing her from detention. So understand that everything don't have to be turned over, but oh, she said not you. Oh, okay. Oh, okay. Thank you, Reb. I thought you was talking to me. Okay, thank you. But March the 25th, which is Wednesday. So now let me ask right quick. Let me just ask ChatGPT something because I'm not exactly sure. So I want to know. So y'all would know. Give me 1 second. I'm going to ask, how long after the appellate court receive all evidence before they decide on a ruling? Okay, so I asked how long after the appellate court receive all requested evidence that they have to decide on a ruling, and it says, let's listen.
Great question. And this is something a lot of people misunderstand because appellate timelines are not quick or fixed. Typical timeline: after evidence is submitted, once the appellate court has received everything it requested, record on appeal, transcripts, briefs, etc., here's what usually happens. One briefing stage, if not already complete. Both sides, defense and prosecution, submit written arguments. This can take weeks to months, depending on extensions. 2, case is fully briefed. This is the key moment. It means the court now has everything it needs to decide. After that, how long for a decision? There is no strict deadline, but here are realistic ranges. Faster cases, 1 to 3 months, usually simpler issues, clear law or urgent matters like custody or detention. Average cases, 3 to 6 months. Most criminal appeals fall here. Slower, complex cases, 6 to 12 plus months. Happens when multiple legal issues, large record, lots of transcripts, evidence, panel disagreement, judges debating, court backlog. Important things that can delay it. Oral arguments scheduled, adds time. Judges writing detailed opinions, reassignment between judges, high profile or controversial case, motions filed after briefing. Key term you might hear, under advisement. Judges are reviewing and deciding. Once you hear that, you're basically waiting on the opinion.
Okay. So 3 to 6 months minimum before a ruling if the appellate court just got everything. So, damn, that's a long ass time. But it also says 1 to 3 months if it's based on custody or detention. So this one is detention. God dang, that's a long ass time. Wow, I'm just floored. I was thinking weeks, but right now it says it could take anywhere from 1 to 3 months if it's dependent on detention. However, with a high profile case, it could be anywhere from 3 to 6 months. Damn, that is crazy. She already started uploading on Friday. Hopefully it'll be quicker than that. God damn, she already started. It's on the docket. Let me ask that then. Hold on. If it's already being reviewed, and they asked for more evidence. Hold on, let me just put exactly what they asked for. Hold on, let me get the paperwork. I'm just gonna post the whole thing. Cause 3 to, whew. Child, I would just, whew. I wouldn't know what to do, baby. Ooh, let me just let y'all hear. It still say a long ass time. Good Lord.
This document actually tells you something very important about where the case is right now. What this order means, plain English. The appellate court already started reviewing the case, but they realized we don't have everything we need to decide this properly. So they issued an order saying, send us all exhibits, including video, from the pretrial detention hearing. Translation for your audience. This is key. This case is not ready for a decision yet. It has basically been, open quote, paused mid-review to gather missing evidence, close quote, what happens next, timeline breakdown. Step 1, evidence deadline, due by March 25th, 2026. Step 2, clerk sends it to appellate court, usually a few days to 1 to 2 weeks. Step 3, case goes back under review. Judges now re-review everything with the new evidence. So when could a ruling come? Now that we know this, the real clock does not start until they receive that supplemental record. Realistic estimate after they receive it, 2 to 4 months, if straightforward.
Oof.
3 to 6 months, most likely. 6+ months if the video evidence creates disputes. Why this order is a big deal. This part right here is open quote, any exhibits, video, or otherwise from pretrial detention hearings, close quote. That tells us the judges think the detention decision may depend heavily on actual footage evidence. They are not just relying on written summaries. They want to see for themselves what really happened. That usually means there are credibility issues, or the lower court may have made a decision without fully considering key evidence.
Oh, y'all heard that? Did y'all hear that? So it still said 2 to 4 months or 3 to 6 months, right? But it also says that this right here, by them asking for all exhibits, videos, and everything that was given in pretrial detention, It means that the judge think the detention decision may depend heavily on actual footage evidence. They are not relying on written summaries only, and they want to see for themselves what really happened. That usually means there are credibility issues, or the lower court may have made a decision without fully considering key evidence. And I believe that's what happened. I believe that they did not consider key evidence. You saw the judge was like, oh, this restraining order don't mean shit. Oh, we don't care about no past threats. Oh, we don't care nothing about that. We don't care that she pulled up. We don't care that she was blocked in. They didn't even look to see, because she was clearly blocked in. Despite all these bloggers going around saying, she wasn't blocked in, she wasn't blocked in, she wasn't blocked in. She was definitely blocked in, and Ari has proof of that. The judge was like, no, I think witness number 3 is credible. No, I think who's not credible is Carlos. And had all these bloggers out here screaming the same thing. Aha, the judge said Carlos not credible. Carlos not credible, but number 3 is credible. Number 3 is credible. They're going to cry if she is released. And the reason being is because they thought they had it in the bag. They thought that it was pretty much done. She was in prison forever, forever, ever. They did not think for 1 second that the judge could have gotten it wrong. Now, I'm going to save my little speech until she's released, so I won't have egg all over my face, okay? I'm going to save my little speech. But I believe a speech is coming, okay? I believe a speech is coming. She said, state knows that detention gives them leverage and weakens the defense into a plea. I think they're fighting hard and backhanded with vague info for detention, a way to give Holly some time in a weak case. I honestly believe that they wanted to give her some time too. I believe that they wanted her to, so they could say, well, at least she did 6 months. And I'm going to tell you something. I believe people that do not like Holly, the Holly haters, I believe they'll be like, well, so she still went to jail. She still went to jail. I don't care. She spent Christmas in jail. So if she's released from the appellate court, if she is released, I sense that we're going to hear, it don't matter. She still went to jail. She didn't see her child's first birthday. She was in jail for Valentine's Day and Christmas, and so we'll still hear that. I think they may be satisfied that she went to jail, period. But I do believe that some of them will be mad because they really thought that detention court meant that was the end, the be all do all. And plus they was out here talking big shit. However, I'm gonna hold my speech or whatever, but I do believe that she will be released. One good sign in this whole thing is that the court wants the evidence that attorney Ari mentioned, in her write-up. And I think that they're going to consider it, because you got to think about it. Witness number 3 was not being honest. So the fact that if there is video footage of her being in another place, but she came forth and told the star witness told all of these fabricated freaking stories or whatever, or fabricated stories, how can you hold that against Holly? Because you find somebody that want a lot of attention out here that would embellish a whole damn story when they were nowhere near the crime scene, right? So I think that if this is the case, if they do decide on this case, now I don't know if they'll decide and say, yeah, we agree with you, witness number 3 is not credible. Because if that's the case, then, oh my God, woo, then that's going to be a game changer. Now, I don't know how it goes. I don't know if they would do that, or would they just look at the fact that there are some conditions that she could be released on. You know what I'm saying? So with that being said, I believe that the appellate court is going to release her. You know, she said, I believe a hearing judge doesn't decide Lowe's credibility for trial. Can you look that up real quick? Oh yeah, I think I did look that up, and you're right. Okay, so let me read. Let me write it how you said it. So I asked. This is the question that I asked. I said, can a detention hearing judge decide whether a witness is credible or not? Asking because witness one is the boyfriend and child's father of both the victim and the defendant, and the judge made reference that witness one is not credible due to bias. Okay. All right, let's hear what it has to say. All right, here we go.
Yes, a detention hearing judge can assess credibility, including saying a witness is biased or not credible. But there's an important nuance you can use for your analysis. What a judge can do at a detention hearing. At a pretrial detention hearing, the judge is allowed to evaluate credibility of witnesses, consider bias, motive, and relationships, weigh conflicting testimony, decide what evidence is reliable enough for a detention decision. So when the judge said the boyfriend, who shares a child with both women, is biased, that is legally allowed. In fact, that kind of relationship is a classic basis for bias. Here's the critical part. This is where appeals come in. A detention hearing is not a full trial. That means the judge's credibility finding is preliminary, based on limited evidence, not final, not binding at trial. Where it can become a problem, appeal issue. The appellate court may step in if the judge over-relied on bias alone. Just because someone is biased doesn't mean they're lying. Ignored corroborating evidence. Did other witnesses or video support him? Made a credibility call without seeing key evidence. This ties directly to your document. They asked for video. Used credibility to deny detention improperly. The decision must still meet the legal standard. Clear and convincing evidence, depending on jurisdiction. Applying it to your case, this is the T. You said, witness equals boyfriend, father to both sides. Judge said, not credible due to bias. That alone is not enough to completely disregard him. So the appellate court is likely asking, open quote, did the judge dismiss him too quickly without looking at everything, including video, close quote. This connects perfectly to that order you showed. Remember, the appellate court asked for all exhibits plus video. That strongly suggests they want to independently assess credibility, meaning, open quote, they may not fully trust how the trial judge evaluated that witness.
Okay. So in basically in detention, yes, they can deem him credible or biased in detention. However, that's right there, but it's not a full trial, which means that he's not, they can do that for detention purposes. However, at the trial, the judge is not going to be able to say that. You know what I'm saying? They're not going to be able to say, oh, no, he's not credible due to bias, if they call him during, back and forth, what is it called? Cross-examining or whatever, or, during the witness's time, the judge won't have that decision. The judge won't be able to say, oh, that person is non-credible. No, they'll be able to do it, use him if they can. Now, if he's deemed non-credible, he's non-credible. If they catch him in lies like they did number 3, then he can be impeached for non-credibility. However, we don't even know if they're going to use him. We don't even know if they're going to use number 3. You think they are, but who knows, right? She said, I believe a hearing judge doesn't decide Lowe's credibility for trial. Can you look that? Oh, I just looked that up. Appellate bonding hearing are expedited, so it usually 14 to 21 days. Let me ask. Okay, let's hear what it said. Let's hear what it said.
Short answer, yes. Appellate bond, pretrial detention, appeals are expedited, but not strictly 14 to 21 days. That time frame is more of a goal ideal, not a guaranteed rule. Let's break it down clearly for your case. What kind of appeal this is, you're dealing with pretrial detention / bond appeal under Illinois law, Safety Act framework. These are treated as, open quote, Priority expedited appeals, close quote, because someone's liberty is on the line right now. Is there a 14 to 21 day rule? Kind of, but not strict. Courts aim to move these fast. Many are resolved in about 2 to 4 weeks after the case is fully ready. But that clock only applies when record is complete, briefing is done, no missing evidence. Why your case is not on a 14 to 21 day track. That order you showed changed everything. The court said, open quote, we need more evidence, videos, exhibits, close quote. That means the case is not fully ready. The expedited clock is basically paused, reset. What happens now? Step 1, evidence due March 25th. Step 2, clerk sends it up few days, 2 weeks. Step 3, case becomes fully submitted again now, the expedited timeline, realistic timeline. From today, after March 25th submission, fast 2 to 4 weeks, likely 3 to 6 weeks. If complicated, 1 to 3 months. Why this one might take longer, important for your analysis. Because there's video evidence, there are credibility disputes, the court already showed concern about the record. That usually slows things down a bit, even in short answer. Yeah.
Oh, it says even in expedited cases. So it says, I clicked it off too quickly. It said that usually slows things down a bit, even in expedited cases. So yes, bond appeals are supposed to move fast, but this one got slowed down because the appellate court said, hold up, we missing evidence. So now the clock doesn't even start until they get that footage. Okay. So bottom line, appellate bond hearing are expedited, not guaranteed in 14 to 21 days. Your case is currently paused for more evidence. Expect ruling a few weeks after March the 25th minimum. So we'll see. Hopefully it ain't long. Ooh, Jesus. Hopefully it ain't. Ooh. Hey, Miss Fee. What's going on, girl? So anyway, y'all, I think that, I don't know, honey. I actually got a good feeling. I really do. So let's just continue to see what's going on. Let them continue to make their little funny photos and say all type of crazy, weird stuff or whatever. You know what I mean? But let's just see, we don't have to respond or whatever. Well, I don't know what other people do. They just don't control what I do, honey, because listen, I'm going to do what I do. She said these judges should be careful with what they say in these hearings, being that Ari is also an attorney for rights, because I myself was floored when one judge said, no matter what you bring me, it's a no. Yes, I do believe that judge said that. He did in the beginning, the first one, the black judge, he says, I don't care how many motions you file, I'm still going to say no. He did say that. That was that was personal, baby. I don't know why it's personal, but that felt personal to me. So yeah, that was a little cray-cray. And I think that empowered the state. You know what I'm saying? I think the state thought, oh, we got it in the bag. Shoot, we got this in the bag. You know what I mean? But not so fast, not so fast, not so fast. That's not what the evidence say. You know what I mean? But nevertheless, thank you guys for being an amazing audience. I appreciate it. I can't believe we stayed in here with at least 200, almost 2, the entire night. Let me give y'all a thanks for sending me some love. I appreciate it. If anybody else want to send some love, look, I made this little neat thumbnail. If you are enjoying the live stream, consider supporting the host with a super chat or a cup of coffee. The coffee link is pinned above if you guys would like to support this live stream. No, no obligation, only if you want to. I appreciate any and all. Thank you so very much. Thank you, Bonita. She said, break it down more. Thank you so much. Thank you, Rachel Ray. Got me waking up in a slight panic, thinking I missed the more live. Thank you, girl. I know Candy Girl over there snoring. She said, if you can't hear more. Okay, that's what she said. Thank you, Candy Girl. Joanne, thank you. Bonita, thank you. Tawana, thank you. Miss Carla, thank you. Candy Girl, thank you. She said, y'all are more really be educating us. Let's support and show love. She is the best to ever do it. We don't just get entertained. We learn, let's support. Thank you, Candy Girl. Appreciate you so very much. And thank you, Perfectly Imperfect and Miss Gumbus. Thank you so very much. I do appreciate you guys for pouring into my live. I also appreciate you guys for the views, the likes, the thumbs up, the shares, and the comments. I do appreciate all of it. So thank you guys very much. I will be back tomorrow night, and I think we're going to be talking about Stony, baby. Stony, child. Stony, honey. Oh, thank you, Lavette. Appreciate you. I didn't even know you was still in here, girl. I thought you was out on a date, child. I guess it is 3 in the morning. Ooh, child. She's like, Amore is the ghost. The goat live you. Love you. Oh, that's what you meant. Girl, you have sleep over there, aren't you? Thank you, Lavette. Appreciate you. So anyway, y'all, thumbs up this video on your way out, and I will talk to you guys tomorrow. Love y'all. Bye now.
Because they can't make $1 without mentioning down one of our names.
Jay! She kept talking about that family.
Hoes over there.
She kept talking about that family. 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 That family. She kept talking about that family. Talking about that family.
These motherfuckers that we want to listen to. Because they can't make $1 without mentioning down one of our